All right, good evening, everyone. It's 6 o'clock, apparently, by different clocks around the building. Good evening, everyone, and welcome to this planning meeting of the Melton Borough Council. I'm Councillor Alan Thwaites, the Chair of Planning. Some housekeeping. In the event of having to evacuate the council chamber, please leave by one of the 6 emergency exits around the sides of the chamber. Please assemble at the far side of the front car park nearest the park entrance. Officers will be on hand to assist anyone who needs any assistance. Please put your phone to silent during the meeting. We will be using the audio-visual system this evening, and the meeting will also be streamed live on YouTube. Members speaking, please raise your hand if you wish to speak and speak directly into the microphone in front of you. Remember to turn it off once you have finished. Members voting will be by raised hands. I'd like to introduce those present this evening. The members this evening are Councillors Pip Allnutt, Ian Atherton, Siggy Atherton, Ronan Brown and Councillor Marilyn Gordon. To my left, Councillors Mike Brown, substituting for James Mason, Councillors Margaret Glancy, Pat Cumbers, Lee Higgins and Dom Pritchett. We have a team of officers present who are, to my left, Senior Solicitor Tom Pickwell, to my right, Planning Development Manager Louise Parker, Assistant Director for Planning Sarah Legg, Planning Officer Helen White, and Planning Officer Mark Ketley. We also have our Democratic Services team present, assisting with the technology and taking the minutes. That's Adam Green and Sarah Evans. So moving on to the agenda. As far as I'm aware, we have one apologies for absence, which is Councillor James Mason, which, as I said, is substituted by Councillor Mike Brown. I'd like to move, there's no other apologies, because everybody's here. To move on to the minutes of the last meeting. There is one small amendment that was raised during the briefing, which I'll just say. The actual bullet point read, the National Planning Policy states that developments should create environments that are safe and accessible, and the fear of crime should not, which was missed, undermine the quality of life. So that was one small change. Is there any other changes that anybody would like to make to the minutes? Councillor Gordon?
Yeah, it's to Ashby Folville, Ashby Folville Manor at Gadsby Lane. I did say something that doesn't seem to be in the minutes, because I know we don't do it word for word, but if I just read what I say and then you can decipher it how you want to go in the minutes. So this is it. This is one thing I'm really worried about, is that somebody else, if they do this and it goes through, is that another developer or somebody that owns a place of importance, they might think, oh great, we can get this done, and say we can build a home or a house that would pay for it. So I am a bit worried about the precedence of this, and if this did happen on another application and it was refused, on appeal it might go back to this one if it is approved.
According to the legal advice, is that as we actually refused the application, there was no precedent set on that.
Yeah.
Sorry. All right. Okay, and then each application will be judged on its own merits.
Yeah.
Each time. Yeah.
Okay. Yeah. Okay? I just thought I'd just clarify that. Thank you.
Thank you.
Lovely. Thanks.
Right, so the next one, moving on to declarations of interest. Oh, sorry, I'd therefore like to move the minutes. Would everybody accept the minutes? Sorry, proposal. Councillor Gancy, Councillor Cumbers to second, and to agree the minutes. That is passed. Yeah, thanks very much. Declarations of interest. Members to declare any interest as appropriate in respect of items to be considered this evening. Are there any members that wish to declare an interest? Councillor Brown?
I've got 2 interests that I'll declare. 4.3 Thorpe Lag Lane. The applicant is the chair of the Melton and Syston Conservative Association. As I'm the leader of the Melton Conservative group, I just think perception would be best that I leave the room at that stage, and we do obviously know each other, so I think that's for public scrutiny. The second one is 4.5. At the last time this came to council, I declared an interest due to a significant business transaction I was involved in with the applicant. I only think it's right that I declare the same interest and leave the meeting. Although the transaction has completed, I just think perception and it would be right for me to not be in the room for making that decision. Thank you.
Councillor Allnutt.
I don't wish to declare an interest, but in view of what Councillor Brown has just said, could I suggest that 4.3 is taken after 4.4 so that he can leave and not come back, if you see what I mean? Just a suggestion.
Any objection to that? No. So we'll move 4.3. We'll do 4.4 before 4.3. Yeah. Okay. Any other declarations of interest? Councillor Higgins.
Just as we spoke just before the meeting, it's not an interest, but I did request to speak on the application 2301159 FUL. But as I spoke with the solicitor and just as yourself, it's probably better to raise as just a very short, urgent item that any other business, if that's okay. But obviously the length of the meeting, it's a very short point I'd like to make.
So you'll remain in the meeting and remain a participant of the committee?
I will on that, yes, because I don't have any other interest or whatever. I was just going to speak as ward member, but the solicitor suggested it was better that I made the point in urgent business, if that's still okay with yourself.
Yeah, okay. Anyway, any others? No, thank you very much. Therefore, we'll move on to the schedule of applications. And we will start with application 22/00063/FUL, the land Castleview Road, Easthorpe. And I believe it's Mark to make this presentation. Thank you, Mark.
Yeah, thank you, Chair. Evening, members. So this application relates to a parcel of land which is located near to Bottisford and Easthorpe, which is shown just on the slide there in front of the members. You can see from that the site is immediately north of the A52 Bottisford bypass. It's triangular in shape, measuring around 1/2 hectare, and the village of Bottisford is around 1/2 kilometre to the west. Easthorpe around about 250 metres to the north of the site. Just next slide, please. So the proposal is for the change of use of the land in question to accommodate 2 gypsy and traveller pitches. In total, the proposal would involve the siting of 2 mobile homes, 3 touring caravans and a utility block, which would incorporate kitchen, dining and bathroom facilities to serve the 2 mobile homes. Off-site highway improvement works on the A52 are also forming part of the proposal. I will come on to explain those in more detail, but ultimately they're required to facilitate safe access to the site in line with advice received from National Highways. Next slide, please. So this is the proposed site layout. You can see the A52 just running along the bottom of the slide there, and the proposed means of access to the site in the bottom left-hand corner of the slide. Within the site itself, there would be a hard standing area across the western portion, and on there would be sited the built elements that I've just explained in the description of the proposal. So just working around the site, in the top left-hand corner or the top northwest corner of the site, there's the square box is the proposed utility block, which, as I said earlier, would incorporate the kitchen, the dining and the bathroom facilities. Either side of that would be sited the 2 mobile homes, which are the longer rectangular shaped blocks on that plan. The 3 touring caravans, which inevitably would be movable structures, they would be again parked next to the 2 mobile homes as shown on that plan. Another item just to identify on that plan, which has been raised by a number of objectors in representation to the application, is the potential impact or otherwise on the public right of way which crosses a part of the site. You can see there just on the bottom left-hand corner the position of the public right-of-way, and as you can see, it crosses over the proposed access into the site on the A52, which is an existing access, incidentally. The gated entrance to the site would actually be north of the route of the public footpath. Therefore, there would be no impact on the footpath and no impingement of its continued use by pedestrians. Next slide, please. So this slide just shows the proposed utility block. The image on the left is the proposed floor plan, which, as you can see, has kitchen and dining facilities and a small bathroom with toilet, which would serve both of the mobile homes as a shared facility. The elevational images on the right hand of that slide just show what the building would look like, which would be a very small single-story timber-clad unit. Next slide. So to facilitate safe access to the site, the National Highways have recommended the introduction of a ghost island onto the A52. The plan at the top left of that slide shows the proposal, which in effect takes the form of a right filter lane when travelling from east to west on the A52. We appreciate that image isn't particularly clear and members might struggle to understand exactly what is proposed. So in true Blue Peter fashion, we have presented an image of one that was prepared earlier. So this is just slightly further west on the A52 at the turn into Bottisford. And this shows exactly the type of highway improvement works that will be carried out, which, as I say, would be the introduction of a ghost island or a right filter lane, very similar to that image shown on the bottom right slide there. Next slide, please. The key policy considerations are obviously set out in the report. Just to summarise those, the site is located in the open countryside, where national planning policy and local policy, SS1 and SS2 of the Melton Local Plan, are restrictive towards new build development. However, the council is currently unable to demonstrate with evidence a 5-year supply of deliverable land for gypsy and traveller sites, and that is a matter which attracts significant weight in favour of the grant of planning consent in this case. That is consistent with the approach advocated by national planning policy, and it is consistent with recent appeal decisions in the borough, of which I'm aware that members were drawn attention to yesterday. From a design and a visual impact perspective, the proposal is considered to be acceptable. The site is heavily screened from both the A52 and from the surrounding field network, to the extent that the proposal would be largely hidden from view from public vantage points. So it is therefore acceptable in landscape and visual terms. There are also no objections from any of the other technical or environmental consultees, subject to the conditions that are recommended in the officer report. So on the basis of the report, this presentation, and obviously on balance, it's recommended that members approve the application subject to the conditions that are set out. Thank you, Chair.
Thank you, Mark. Do any members have any questions for clarification of the presentation or the details? Council?
Thank you, Chair. I notice in the briefing pack we've got the proposal front page includes a sewage treatment plant. That's not mentioned anywhere else in the document, nor was it mentioned in your briefing. Just, is the proposal to include a sewage treatment plant or not, please?
Yeah, thank you, Councillor Pritchett. The proposal does indeed include the installation of a package treatment plant. If we could just go back to the slide of the proposed site layout, and I will be able to advise exactly where on the site that would be positioned. Slide number 4. Yeah. So the treatment plant, it's not particularly clear on that slide, but it is in the very bottom left-hand corner of the site. You could just see a very faint orange line running from the utility building underneath the mobile home and the two touring caravans down to that bottom left-hand corner, and the treatment plant would be positioned there. The Severn Trent Water have been consulted on the application, as indeed of the Trent Valley Internal Drainage Board. Their comments are set out in the report, and they are accepting of the proposal in that respect.
Councillor Pritchett.
Thank you very much, Chair. Thank you, Mark. I got some my questions are focusing on the conditions. We've had the response back from National Highways about the visibility display and the alterations of the road. One thing that's missing for me, serious thing that's missing, of which you would get from LCC, is when you pull off the road, the refuse, the waste people that come round, the Amazon delivery and visitors, you normally have to provide a turning area so you can come out in forward gear, right? That bit seems to have been left off this, and that's a huge concern to me. The other thing is the guidance from government on planning policy for traveller sites, updated in December, said local planning authorities should not permit mixed use on rural exception sites. There isn't a condition preventing business use on this particular site, and 10.3 itself is rather confusing and doesn't deal with how long any one van can stay visiting, which is a permanent site. And there are some comments on this in relation to limiting business use, specifying the number of days the site can be occupied by visitors. So that's not included, and it reads a bit odd. 10.3, if you read it, it says there'll be no more than one mobile static home and 2 touring caravans at one time, and then it says and no more than 3 touring caravans in total. It doesn't make so. There's the driving in and out and coming out in a forward gear. There's a restriction of the business use. They're the key things, and the informatives. I'm surprised the informatives have not been conditions. So I'll leave you there. It may well come up again in the debate, but I'll.
Mark.
Yeah, thank you, Chair. I think we'll take each point in turn. Again, if we could just go back to the proposed site layout on slide number 4. So in terms of vehicles being able to pull into the site, turn, and then leave in a forward gear, you'll see from that image, Councillor Pritchard, that the entrance from the A52 up to the point where the proposed entrance gates to the site would be, there's clearly a significant distance of around 8 to 9 metres, so that vehicles can pull clear of the carriageway in the event that the gates were locked. Beyond that, vehicles would pull into the site, and you can see that there's clearly a vast hard standing area where vehicles could turn and then leave the site in a forward direction. So we're comfortable, confident that there wouldn't be any safety issues or the potential for vehicles to reverse out of the site.
Practical, sensible thing for the landowner would be to put the security gates their side the public footpath, which gives no problem, and then put a turning vehicle in there. So I mean, from site knowledge, I would dispute the fact that they'll be able to turn round.
Chair, the entrance gates are the applicant's side of the footpath. They're on the right-hand side of the footpath as you look at that image.
Yeah, but as I say, I've not seen anything from any accredited transport people that tells me that will be the case.
I mean, Chair, what you could do, should members be minded to approve the application, is you could impose a condition, an additional condition, in the event along the lines of notwithstanding the details shown on that plan before the site becomes operational, details of a turning circle within the site must be provided. It is within members' gifts to impose that.
Thank you very much. That's what I'm after. And similarly, I'm after a restriction on business use.
Yeah, I mean, again, Chair, should members have concerns about the potential for business use on the site, a further additional condition restricting or preventing business use could be imposed. I mean, any such formal business use would require a plan and application for change of the use of the land in any event. But for the additional security, you could impose a condition to that effect.
Any other members? Councillor Brown.
Thank you. I just wanted to refer to your diagram for the proposed access to the site and your ghost island. I've not heard that term before. It's innovative. But you use as an example another part of the existing A52, which is clearly a planned junction that was part of the design for that bypass. I'm just concerned about the width of the road at the access point with putting in this ghost island. I can't see in the documents there's any reference to any sort of road widening there. And I have driven on the A52. I've never actually measured its width. I think. So I wonder if you could just comment on that.
While you're looking at it, Mark, I think I can say from the LCC document, I think it was 700 mil on each side of the road. It's widening the road. Yeah.
Thank you, Chair. I was hurriedly scrolling through because it hadn't occurred to me before. But
it was in the fine detail.
Yeah, thank you for the clarification.
So it's 1.4 metres to widen the whole road to allow. That was the specification. I mean, I don't know if you want to elaborate on that, Mark. Yeah.
No, Chair, you're entirely correct in that respect. The proposal is to widen the road by 1.4 metres, as you say, 700 mil on either side. There's sufficient grass verge on either side of the road to achieve that, and that would be sufficient to incorporate the ghost island or the right hand turn pocket as shown on the diagram presented earlier.
Yes, sir.
So notwithstanding that that's come from the Highways Authority, is widening a road that is itself only 2 cars width wide by a grand total of 1.5 metres wide enough to take 3 cars, or worse, 2 heavy goods vehicle and a car safely side by side?
Yeah, Chair. I mean, from our perspective, we can only take the advice of the statutory consultee on this, which happens to be National Highways, with it being an A road or a trunk road. We have to take their advice as the national governing body for roads of this kind. And we're not in a position to contradict or question that advice.
If there's no others, can I ask one? I'm sorry, Councillor Allnutt, do you?
It's an interesting comment I just heard. We're not in a position to question that advice. I understand what the officer is saying, that we have to bow to the other agency, but I would have thought we could ask the question: is that really wide enough? Along the lines that my colleague Councillor Atherton just asked. I mean, as you know, it's a bit of a bête noire of mine that I don't trust all these consultee agencies. I start off with a large degree of scepticism, and I do wonder whether sometimes they're doing it on a desk and not really examining it thoroughly. So a question I would have thought we could, and have we asked that? Have we really said to them, are you sure you're about this? Is it really wide enough? I mean, it's a reasonable question.
Yeah, Chair. I mean, just to explain the process in a little more detail, this isn't just a case of one particular individual at National Highways, sitting and assessing this. It is scrutinised, very heavily. But in addition to that, there is also the road safety audit process, which is undertaken, and members will have seen from the documents available on the planning portal, the road safety audit stage 1 document has been carried out. That has been independently assessed, and also assessed by National Highways, and a design response subsequently prepared, which is ultimately the response or the proposal that is before members this evening. So it has followed established process in terms of assessing the safety and ultimately the mitigation that needs to be required for implementation to ensure safety moving forward.
Councillor Higgins.
Yeah, it's not come much in the presentation, but I don't think it's point of clarification, because in the interactions and the briefing, there was an email which had an appeal on, which I think is going to weigh on this debate. But it's just going to the paragraph 19 to 21 of that appeal. And if the officers can't answer it straight away, I'm happy for it to be clarified after the speakers. But in paragraph 21, the inspector says, who overturned the refusal and said, I accept that the pitch requirements relied on by the council are probably there or thereabouts, as there is no compelling evidence before me of a significant increase in the need on the ground. And indeed, the appellant's evidence was that there may be a requirement for some additional provision in general terms. And then they put in brackets, not taking account of these appeals. However, there is a need for these two families to live somewhere, and the council confirmed that there are not any other suitable available pitches in the borough. This is indicative of an immediate unmet need for sites in the council area, and I therefore attach considerable weight to the need for pitches in favour of development. Now, obviously, the sort of question for clarification is that inspector was saying in paragraph 21 that it was indicative of unmet need at that moment in time. Because would it mean that if anyone keeps coming in saying, I need a pitch to live, would that always keep meaning it's unmet need all the time? And that's just my point of clarification, because otherwise everybody's going to keep saying, I'd like a pitch, like a pitch, like a pitch, and that's unmet need. Thank you.
Sarah?
Thank you, Councillor Higgins. Yes, so for now, yes, that remains the case until we have our updated evidence base in terms of the local plan review. So that evidence base is being updated at the moment. Once that is updated, then we will be able to rely on it. But at the moment, the evidence is out of date, as it basically says in that appeal. So we are without a 5-year land supply to be able to demonstrate for gypsy and traveller sites.
The last one, going back to the road question, the widening and the signage and the road and painting, etc., that will be done at the cost of the applicant?
Yes, that's correct, Chair.
And the requirement you put in the proposal was that that would be completed before any occupation or any work of any sort on the site, that the road changes must be made first.
Yes, that's right, Chair. The actual wording of the conditions recommended by National Highways, it was for those works to be carried out before the site becomes usable or occupational. However, we have taken on board the concerns of both members and members of the community who've written in objection to the application, and we have in certainly condition 10.8 recommended that those highway works on the A52 are carried out before any development commences on site.
Thank you. Any other questions? No? Thank you. Sorry, Councillor.
Yeah, I'm a bit worried because there's been a lot of accidents on that area. And when we went to visit, on the site visit, there was an actual accident there then, and the police were there and everything. So, but I do know that we've had an email from somebody and showing us pictures of when he had a bad accident.
Sorry, is this a question, Aaron, or do you want to put this into the debate?
Oh, I'll put it into the debate. Sorry. Yes.
Thank you.
Yeah,
No.
thank you.
No, but I follow your thinking. Thank you. In that case, if there's no more questions for clarification, we'll move on to the speakers for this evening. We have one speaker, which is Ben Wills from 360 Rural Limited. Mr. Wills, if you'd like to come forward. Thank you. Please take a seat. You'll see the microphone in front of you. There's a face. If you press that, the red light will come on. You'll have 3 minutes. And at the end of the 3 minutes, well, about 30 seconds, Tom will give you a warning that the 3 minutes is about to be up. And then if you'd like to stay there for any questions that the members may like to ask. Thank you very much. So when you're ready, please start.
Thank you. Firstly, thank you for the opportunity to speak against this application. I've been instructed to represent a number of local residents. I am somewhat surprised that Melton Borough Council have deemed the application to be valid. The agricultural tenant has not been served with the appropriate notice, and evidence has been supplied to Melton Borough Council by various parties to confirm this. A tenancy under the Agricultural Holdings Act 1986 or the Agricultural Tenancies Act 1995 need not be in writing. The tenant occupies under the terms of a tenancy governed by the Agricultural Holdings Act 1986. Melton Borough Council have received communication from the agricultural tenant and their solicitor confirming an agricultural tenancy is in place, a copy of a previous planning application in respect to the same site where the tenant was served with the appropriate notices, and a copy of correspondence from the current owner and applicant who unlawfully took up occupation of the land in breach of the tenant's rights, the outcome of which was the unlawful occupiers were removed from the site in order that the tenant could resume occupation in accordance with their tenancy. What further evidence is required by Melton Borough Council to confirm that the appropriate notices have not been served? The statement in the Planning Committee papers is factually incorrect and I believe misleading. The property is occupied by an agricultural tenant. We remain concerned about the proposed planning condition dealing with access matters. The proposed condition in this regard has been strengthened. However, we feel that given the historic road safety issues with this stretch of the A52, only last week being highlighted in the Melton Times again, this requires a stronger condition to be implemented. We are aware of similar applications where wording has been included to strengthen such matters to ensure that all works to the proposed access are completed before anything else happens on site. It is asked whether a Section 106 would be more appropriate and robust in this situation, given the issues of highway maintenance, to ensure compliance, especially with significant costs associated with widening the A52 by 700 mil on either side. This is a significant point. It is also worthy of note whether this site is deliverable, given the significant works required to the A52. Policy C6 specifies that sites must have a safe and convenient access to the road network. Given the required works, is this site deliverable, widening the A52, and at what cost? We wish to put on record our concerns regarding pedestrian highway safety, and specifically the focus within the report to this committee that the site is well located, 0.6 of a kilometre from Bottisford and 0.2 from Easthorpe. There is a significant health and safety risk about the occupation of this site and families potentially using the A52 to access the adjoining villages on foot. This is not addressed. The site does not have a safe and convenient means of access, far from it. A more suitable and safe site would be much more appropriate and in the interest of both the applicant and, more importantly, their family. Pedestrian access has not been considered. The inability to demonstrate a 5-year supply of deliverable sites should not result in the grant of permission for an unsuitable site which does not meet in full the requirements of policy C6.
Thank you very much. Thank you very much. If you'd like to wait there for a second to see if any members. Councillor Higgins.
Yeah, thank you for the 3 minutes. I'm sure the solicitor will talk about some of the legal points, so he's more learned than any of us. But you said there was a part of the report was factually incorrect. Could you tell us which part of the report and the paragraphs? That might be really helpful.
Yeah, there's an extract at, I believe, 7.18, which says, suggestion has been made that the application site is the subject of a lifelong agricultural tenancy agreement and part of the agricultural stewardship scheme, full stop. Some information has been received that shows there was some form of legal action over the site. However, this did not prove an agricultural tenancy itself, full stop. It's that paragraph which I believe is factually incorrect and misleading. Under the Agricultural Holdings Act 1986, a tenancy can be oral. This tenancy is oral. There is a tenancy. In previous situations, there has been notices served on the agricultural occupier. This has not happened.
I didn't catch the actual paragraph number. That was my fault, though.
7.18, I think. I've snipped it out from the report.
Was there any follow-up questions? No? Tom, would you like to? Yeah.
Thank you. So, members, we did receive some correspondence, the main thing being a court order for possession, and that showed that a third party took possession of the site. What that didn't do, though, was specify that there was an agricultural tenancy. So whilst that might have been the implication, the court order did not prove that per se. The planning officer then put this to the applicant directly, who confirmed that there was no agricultural tenancy on the site. That is the only position that we can give you.
Any Councillor Higgins?
Just while the speaker's here and what Tom said, so are you the tenant of that, or do you have any evidence of that?
Thank you. I'm a chartered surveyor with 20 years experience in rural matters. And the reason I reference the Agricultural Holdings Act 1986 is that Melton Borough Council have been informed by the tenant they have a tenancy. A tenancy under the Agricultural Holdings Act 1986 does not need to be in writing. The fact that the tenant is there and is in occupation, has been there since before the 1st of September 1995, means that they have a tenancy governed by the Agricultural Holdings Act 1986. The reason I make that point is a tenancy does not have to be in writing. The reason the legal paperwork has been shared with Melton Borough Council is because the tenant, when they had occupation of the land by a third party, went through the courts to prove that they should be in occupation of the land. The court would not have removed the applicant from the site had they not felt that a third party, who must be nothing other than the tenant, should have been in occupation of the site. That third party remains in occupation of the site. They're an agricultural tenant, and that was my point within my comments earlier. What further evidence is required? I mentioned in one of our representations of the council, it is an offence to make a misrepresentation. I think there's a fine of £5,000. The tenant has told this council there is a tenancy. The court have evicted somebody who occupied the site unlawfully. The previous planning application served a notice on the tenant. What more can we give, unfortunately?
Yep, well, I'm not disputing the legal position about written tenancies. I think the difficulty is that the planning team, they don't have a proof of that, and I appreciate that it doesn't exist in writing, but what they have is a third party saying that there is a tenancy, and they've got the applicant saying there isn't a tenancy. So what they're faced with is two different things that conflict with each other.
My point being, how can we possibly prove any more than what we've done to say there is a tenancy in place? I'm very conscious I might not be able to come back and say that, but we've done all we can to explain that. The application, in our opinion, is invalid because of that. All that needs is resubmission, a notice, and follow the right procedure. Procedures are there for a good reason, and we can't understand why they're not being followed in this case.
Sorry, we're just taking the points here that you're taking. So what proof would you be able to bring if we made a deferral? I'm not preempting anything. If we made a deferral, what evidence would you be able to bring in the future?
You could have the tenant for one. You can have some form of affidavit sworn. You can have any of those things that you need. The point is, we've made all of these points. We've sent them in. They've been discounted. And the point that we really struggle with is, what more can we do? You can ask me to swear under oath that that individual has a tenancy. They do. The point there is this application is not valid, and therefore we shouldn't be here and we shouldn't be discussing it because it isn't valid. We've flagged the point multiple times, multiple emails, and it's just not being listened to. And that is unfair on the part of the tenant, because what more can the tenant do?
Councillor Pritchett was first.
Thank you very much, Chair. Thank you for coming this evening, Ben. When the site was occupied before, it was occupied without planning permission. These tenancy arrangements, lifetime tenancy, do they provide for a notice period?
That's a very good question, and I think it slightly strays out of planning, but I'll respond to it if that's okay. An Agricultural Holdings Act unwritten tenancy does not have a short-term notice to quit, so you have to therefore follow Case B under the Agricultural Holdings Act of 1986. There is no short-term notice. That may be a year's to 2 years notice to regain occupation of the site. The Agricultural Holdings Act 1986 is a very relevant and very complex piece of legislation. And I think within this application, whilst the tenancy is being not referred to, you know, that there is a real flag here that legally this site cannot be occupied in the short term until that notice to quit takes effect. An oral tenancy is covered by the 86 Act.
Basically, I think what the gentleman's saying is that whilst there is this notice, if planning permission was given, but if we continue tonight without formally accepting the agricultural holdings agreement, that may be more difficult later on for the tenant, I think.
Councillor Siggy Atherton was next, and then.
Thank you, Chair. This might be a very naive question, but if you're asking for proof from this side, why are we not asking for proof from the other side for the applicant? Just saying his word, then that word should be equally good enough.
I think that's where we're coming to a problem, and it is one person's word against another person's word. Yeah, it takes some advice from Tom.
So I think there's a couple of points here. So the actual tenancy itself is effectively a civil law matter in that anybody can apply for planning permission on anybody's land, and that's a secondary issue. And I don't think we need to get concerned with that. The legal point that the speaker raises is that the applicant is required to give notice if there is an agricultural tenant on the land. That hasn't happened, and as I've already stated, you've got two words against another. In the event that it was established that there was an agricultural tenancy, effectively that invalidates the whole thing. It would be a Virey's decision. The decision could be quashed. It's difficult because my normal advice in this situation would be to look at a deferral for further information. It's what that further information looks like, and that proves difficult because, again, yes, you could look at a sworn affidavit. These aren't civil proceedings, so they don't carry any additional weight per se. The applicant could also come forward and do exactly the same thing. That is what creates the difficulty, unless any members have any ideas.
Sorry, carry on.
I think it is relevant. You know, if I was here saying the tenant has an Agricultural Holdings Act tenancy and the applicant was saying he wasn't, that would be one thing. The fact this has gone through the courts, the applicant has occupied the site, been removed from the site, returned occupation to a third party who cannot be anything other than a tenant because otherwise they would have no interest in being on the land. I think that has to carry significant weight.
Sorry, so the papers that I've seen is the order for possession, and all that does is it requires the people that are on the site to give up that possession. I assume that those court proceedings must have been backed up by some form of evidence to establish that. Ideally, if there was something from the courts that gave a judgment to that extent, that would be useful, and the judgment I would expect to actually give the reasons for the order. Do you, I don't know if you were instructed on this matter, obviously solicitors would have been, if such a judgment existed and that gave that, that would be helpful, but I don't know if you're able to answer that.
I don't have that answer, but we can find out. You know, Tim Russ, I know, has been of Roythorns, who was instructed on this matter by NFU Legal. You know, this isn't something that's just happened. It was proceedings that were taken. NFU Legal paid for the work to be undertaken to ensure that a tenant could resume occupation of the site. That happened.
I think we're looking towards a deferral on this. I don't know if anybody still wants to ask any questions. Sorry, Councillor Glancy, still.
No question. I'm just going to suggest that we defer it until we have further information, which would be an affidavit sworn in front of a Commissioner for Oaths, together with any judgment documentation from the recent court case. Thank you.
Yeah, as I've just said, I'm minded not to rely too much on the affidavit, only because if the applicant was to do the same thing, we're at the same impasse in word against word. The ideal would be to have the judgment. So, like I said, I have the order of possession, but all that does is say that possession must be given up. What we need is the reason. If there's something that establishes that, that would be useful. And perhaps that's a conversation that could take place after the meeting anyway.
Just to go back, I'll ask for that and see what is available. But imagine this hadn't been to court, and you've got a tenant saying I'm a tenant, and an owner saying I haven't got a tenant. I find it a perverse situation when you've got this amount of information in front of you about an application that it has been validated. All this needs is a resubmission, the appropriate notice served to follow the proper procedure, and then all of this goes away. And on that basis, why can that not be done?
I think the difficulty is we can't compel an applicant to say something when they are stating the other thing. Of course, if it was to go through and, like you say, you didn't have those court proceedings, the way that that'd be challenged would be through the courts, through judicial review. Evidence would be required at that point in any event to back up that position as to why it's an invalid application, and the courts would then come to that decision.
Councillor Allnutt.
Thank you, Chair. On a point of procedure, we're now in the realms of debate. We've wandered off question and answer. Now, having said that, I think we are converging on a single point here, that committee members are not comfortable, shall we say, with the framework for the legal advice that we are hearing, albeit in good faith. I did raise this tentatively for my brief attendance at the briefing when I was in domestic difficulty and had to leave, but I did say I felt that there were some legal issues that we needed reassuring on, and this was indeed the big one, because I recognise what's being said. Whether it's wholly correct or not, I'm not in a position to judge, but I don't feel able to make a decision tonight, frankly. I sympathise with the law officer who's saying, well, OK, if you want to defer it, you've got to tell me what you want me to defer it for. Well, I think we need to defer the deferral, if you see what I mean.
OK, so for the procedural point of view, I'm going to say thank you very much for your time, and thank you very much, so that we can move into debate. but we have a debate. The only point I really want to make on the deferral, if we make a deferral, we've got to know what the documents that we're looking for, etc. So, Councillor Glancy, I think you already started that.
I think I've already started that, and it's to get the sort of judgment, proof and evidence of the history behind this situation. And I'm sure Tom can liaise to find out what we actually need, and also a sworn affidavit as well, because I know any Tom, Dick and Harry could do that, but that will add some weight as well, I think. Thank you.
I'm happy to second that, but could I just ask, if two parties both sign affidavits and obviously one is lying, what can you do then? What sort of punishment is there for somebody who lies?
Can we cross that bridge when we come to it? Does everybody feel comfortable with we have enough for the deferral and the documents or the actions that we need? We have a proposer and a seconder.
Before you, because I think as Tom rightly said, and to be fair, is I do understand with members of the public, or no matter what their professional background is I think, as you rightly said, Tom, anyone can apply for a planning permission on any piece of land. You can, in one way, apply to knock a church down and build a multi-storey car park. So I always go to that extreme, and an applicant pays their fee to have it determined. Doesn't mean it, that type of scenario would be quickly refused, I would add, I would think anyway. That said, I think what you were quite rightly suggesting there, Tom, is the member of the public who spoke and spoke very well was saying that the application form probably didn't meet the requirements of the legislation of putting the application in, and maybe officers want to look at that as well.
Yeah, thank you. I think that is the whole point, that the applicant is saying one thing, the third party is saying another, and that's what we're looking to resolve.
Councillor Ian Anderson.
So just very quickly, and it's going back to the
Remembering we are on the proposal, so if there's, yeah. Sorry, carry on.
Okay, I was just going to go back to the report where we were talking about the road width. There is actually, I've discovered a document in the repository, which is the RSA1 report of 16th of February 2023, which does show 3 lanes, each of 3 meters wide. So whether that equates to a 0.7 meter wide in on either side, I don't know.
Okay,
but we reference that in the report for the next time there's a meeting about this.
Okay.
Because we might not be here to witness it.
Yeah. Okay. So we have a proposer. We have a second to defer with the comments that have already been made. Councillor Cumbers seconded. Yeah. Would you like to, for those that are in favour of the deferral? That's carried. So the application is deferred. Thank you very much, and thank you very much for the speaker. Therefore, we move on to application 22/01373/ It's the land between 9 and 15 Navigation Close, Melton Mowbray. And I believe it is Mark again. So Mark, off you go.
Yeah, thank you, Chair. So this application seeks outline plan and permission for the construction of a single dwelling on land that sits between numbers 9 and 15 Navigation Close in Melton Mowbray. The application site is identified on the slide in front of you there with the red line boundary. It forms an area of undeveloped grassland, which formed part of the Uplands housing development back in the early 2000s. It sits in the northwestern corner of that housing estate, and other key reference points for members, just so you can pinpoint it for your bearings. The Aldi car park and Aldi itself situated just to the west of the site, as shown on the slide. The Land Rover garage to the northwest, and the new residential care home being built immediately north of the site. Just move on to the next slide, please. So this is the application site, just a slightly more zoomed in fashion, and again just to pinpoint some of the key characteristics and some of the key features of the surrounding area. So as I say, the site itself is undeveloped grassland that was left over as part of the residential development on the uplands. It was originally identified as an area for an equipped children's play area. And that formed part of the original plans submitted with the Uplands plan and application in the early 2000s. However, during the course of that application, it was decided to construct the play area in a slightly different location, just to the southwest of the site, which you can see on that image there. That's called the Valiant Way play area, which is accessed off Valiant Way and Vulcan Close, which meant that this particular application site was therefore no longer required for an equipped children's play area, and it has, as I say, been left over to grass during the intervening period. Contrary to suggestions in objections that have been submitted to the application, it's not protected in the local plan as either public open space or protected green space. It is just effectively undeveloped grassland within the residential setting of the uplands. Other key point to mention, again referenced in objections to the application, is the location of the scheduled monument. That's located to the west of the site, with the long yellow arrow at the far left of that slide. Concerns have been raised by members of the public about the potential impact of this development on the setting of the scheduled monument. However, Historic England have not objected to the application, and the council's conservation officer has also confirmed in their consultation response that the proposal would not cause harm to the setting and would not constitute a reason for refusal of the application. Just move on to the next slide. This presents a photograph of the site as it exists currently. So on the left-hand side of the image, you can just see the gable elevation of number 9, navigation close. That presents a blank gable onto the application site itself. On the right-hand side of the image is number 15, navigation close. That forms a pair of semis with number 11, and obviously the application site sitting in between them. You can just see in the distance there the care home also being built behind the trees and the hedgerow that form that northern boundary of the site. The site itself, as I say, it's not protected in any way for open space or recreational purposes. It has a low post and rail fence which actually prevents public access onto the land. It has been maintained by the residents living immediately adjacent to it, but it is effectively an incidental green space. You can see some small trees on the site which would be removed as part of the proposed works, but otherwise the hedgerow and the mature trees on the northern and western boundaries would be retained, and there are conditions recommended to secure the protection of those whilst construction works are carried out. If you just move on to the next slide, please. Thank you. So the purpose of this application, as I say, it being an outline application, is effectively to seek to establish the principle of developing the site in the manner being suggested, which is in the form of a single dwelling. The matters relating to the detailed layout, scale, appearance and landscape are all reserved for future approval through a reserved matters application, should members be minded to grant outline permission this evening. Means of access to the site is to be considered in detail, and I will explain that in more detail in a moment. Notwithstanding that the detail is effectively pushed down the line for future approval, an indicative site layout plan has been submitted with the application, whereby which the applicant is seeking to demonstrate that a modest 2-bedroom property, a bungalow, could be accommodated on the site whilst providing commensurate areas of garden and amenity space and car parking facilities that would meet the necessary standards required by the Melton Local Plan and the Design of Development SPD. Just move on to the next slide, please. So this is the indicative site layout plan that's been submitted by the applicant. You can see here the proposed 2-bed detached bungalow sitting gable to gable with number 9 navigation close to the south. It would face in an easterly direction out of the site towards numbers 11 and 15. It will be surrounded by garden areas to the west, the east and the north, and obviously with 2 car parking spaces there being provided directly off the turn and head shown on the photograph earlier. As I say, this is purely indicative, and it has been submitted by the applicant to show how the site could be developed with the form of residential property that is being suggested. Just move to the final slide, please. So again, the key policy considerations are set out in the officer report, but to summarise them very briefly, the site forms part of the Melton Mowbray main urban area. It's within already an established residential estate, and therefore it is considered to be sustainable and in an appropriate location for new housing development in principle. In officer opinion, the applicant has satisfactorily demonstrated that the site could be developed with a 2-bed detached bungalow in the manner being suggested without resulting in a sense of overdevelopment, without detracting from the form or the character of the area, and without having an unacceptable adverse impact on the amenity of the neighbouring properties. There are no objections from either a technical or environmental perspective from statutory consultees. So therefore, Chair, on balance, it's recommended that the application is approved, subject to the conditions set out in the report. Thank you.
Thank you, Mark. Councillor Ian Atherton.
So can we just go back to the site plan, please? So the yellow arrow that shows where the scheduled monument is actually pointing to the wrong place. The actual scheduled monument is in about the 3-4 o'clock position from the arrowhead, underneath that large clump of bushes And that's clearly visible on the plan that was part of the original application for Uplands as part of submission 02000388. That same plan also shows a 30-metre zone around the scheduled ancient monument. I can't say that word for some reason.
Put your teeth in.
But it doesn't explain what that 30-metre radius is there for. My assumption is it's some kind of protection zone. There are other planning permissions granted either for or...
Yeah, sorry, these questions, just in clarification at the moment.
Okay, the clarification then is that we're actually showing the wrong location for the scheduled monument. And do we know what that 30-metre zone around the scheduled monument actually is for?
Please, John. No. Mark?
Yeah, thank you, Chair. I mean, the purpose of those arrows, it's not to exactly pinpoint the exact area of the scheduled monument. It's pointing you to the general area. You're never going to be able to pinpoint that on an arrowhead, particularly on an image of this size. That said, as I say, Historic England have previously commented that there would be no harm to the setting of the scheduled monument. Our own conservation officer agrees with that position, and quite critically in that respect, the advice that's come back is that other development within the setting of the scheduled monument in recent years has been far more impactful on the setting, and effectively that has set the bar. So the examples that have been cited, particularly are inevitably the care home and the Aldi and its associated car park, they've set the bar in terms of the impact on the setting of the scheduled monument, and the advice in relation to this application from our conservation officer is that it will not have a negative impact on the setting in the context of what's already been allowed to be developed around it.
Councillor Siggy Atherton.
So we say because we already got a presidency, it doesn't matter, because every time we come here to planning, we get told, no, we go by case. So either we go by case or we don't. We can't have it both ways. I'm very sorry, but...
Okay. Councillor Cumbers.
Thank you, Chair. Yeah, it's this area started off as part of it was going to be a play area, and that was changed. Can you show us on here where the children are meant to play that can't play on that site? Can you show us on the screen? You mentioned Valiant Way.
Yeah, the play area is identified by the middle yellow arrow.
Valiant Way. Are you sure Valiant Way, not Vulcan?
It's Valiant and Vulcan. I mean, this image is clearly taken from Google Earth, and it's quite closely referenced, Councillor Cumbers, that it is the Valiant Way play area. That is what it's titled on Google Earth, but ultimately it's accessed off Valiant Way and Vulcan Close.
Sorry, is the Vulcan, is that where there was a refusal, the 15001448? Is it that play area? Because I can't think that there can be two areas sort of close, and I can't see as well how children on navigation can get to Vulcan Way. The only way I can see...
Clarify, so the officers can come back and assist with that. So we're talking about the play area that's labelled Valiant Way.
Yeah, sorry, I can't see that very clearly, I'm afraid.
So the middle arrow and the lowest arrow, where the mouse is now.
Oh yeah.
That's the play area it's being spoken about. Navigation close is where the site is. So what's the question about?
Well,
I think you're asking hold on just 1 second, Councillor, because you're asking the officers to explain something between navigation close and the play area, but I'm not entirely clear what the question is.
Well, the question is, how do children on Navigation Way get to that play area? Because I don't think there's any way through. I think that the only way possible is out to Dalby Road, along Leicester Road, in a big circle. So it looks all right on paper. It looks as though they're close, but they're not actually accessible.
So this is the question I asked earlier, Mark, that if there was access from Navigation Close down to that play area.
No, Chair, there's no direct access from Navigation Close down to the play area, which I obviously confirmed in email yesterday. You do have to go around the houses, so to speak, to get there.
Yeah, and did you know as well that play area?
Can we stick to questions?
It's a question. It is a question. I'm asking if he knows that that play area it is no longer maintained.
Chair,
sorry.
if I can just interject at that point.
Sorry, you're telling me. Sorry.
Sorry, can we let Mark answer first?
Yeah, Chair, what I was about to say before I was cut off there is that it's not a material consideration as to whether that play area is maintained. We were aware of the potential issues in that respect, and that may be for another element of the council to deal with, but certainly in the context of this planning application and your consideration of it this evening, that's not a material consideration.
Can we come back to this in debate though?
Yeah, no, I'm just not happy with that, because the officer was saying that play area is a suitable substitute for what was planned in the middle. And in fact, at the briefing the other day, I can remember an officer saying that original planning permission would not have been granted except that the play area was able to go elsewhere.
I don't remember that comment, but sorry, Tom, did you want to add something?
Yeah, I think there still might be a bit of confusion because this application has no bearing on the play area. So the play area is not being lost by virtue. It was. So just because the microphone wasn't on, the question was, why was that mentioned? I think it was mentioned earlier because the question was asked about what this space was originally, and originally it was planned to be the play area. When I assume, and I'll be corrected if I'm wrong, when the Navigation Close and the Uplands development was being done, at some point it appears that was changed to move the play area from the space on Navigation Close to the Valiant Way, Vulcan Way. But as far as this application is concerned, that play area has no bearing on it at all. It's just all you're considering is whether this site that you're looking at is acceptable in principle for development. And that is the question that this application and this committee will need to consider.
Pardon, sorry. Should the officer then not have mentioned the play area? This is the substitute play.
No, because the question specifically was, what is the background of this site? So the officer needed to give that information because that was asked explicitly.
Thank you for your patience, Councillor Pritchett. And I'll come to you, next Councillor Atherton, if you'd like to go ahead for your questions for clarification.
Those are my questions. That was sorted now.
Councillor Atherton, Allnutt.
Yeah, I think the discussion around the play areas is relevant, but it's relevant in the context of the debate that we need to have after questions. So I want to ask a slightly different question. We were told that there's an indicative plan, which I hadn't seen in the documents, but we saw. Can I just put the indicative plan back up? Oh, sorry. That's the one. Yeah. Now, it's another one of my old toothaches is that we are often asked to approve something in general terms, and we're sold the old Sally that don't worry, we can work out the details later. And then when we come to work out the details later, we find all sorts of reasons why we don't quite get what was indicated in an indicative plan earlier on, and we end up with something quite different. So my question is, to what extent is that indicative plan firm? Because I don't want to come back in 6 months' time and find we've got a skyscraper or something else. I want, because that is important to evaluating whether or not the plan, the application is reasonable.
Yeah, thank you, Councillor. The proposal is submitted indicatively, but in condition 10.4, what we've specified there is that the details of any future reserve matters application, should members be minded to approve the outline consent, must be submitted in broad accordance with that plan. Now, that plan quite clearly specifies a two-bed detached bungalow, and that is what we would expect to be submitted with the reserve matters application to ensure compliance with that condition that is recommended at 10.4. Ultimately, the detailed design through the reserve matters application is something that we as a local authority would have full control over. But as I say, that condition strengthens it in terms of requiring any future application to be in accordance with the detail that's shown on that indicative plan.
If that's the case, my extra question is, with respect to the car access onto the site and the parking arrangements, would that be part of the firm aspect of the indicative plan, or would that be a bit iffy in my layman's terms?
The position of the car parking itself within the site is obviously subject to detailed approval at the reserve matter stage. This application does seek detailed consent for the access, but by that it means simply the access coming off that hammerhead. The position of the car parking within the site is part of the overall detailed layout that would come forward in the future. So if you had for example, a concern about the position of those car parking spaces at this moment in time, that is something that we could seek to resolve through the subsequent reserve matter scheme.
Councillor Higgins, did you still want?
Thank you. Could you just put the image, not the satellite one? There was an image, I think, from the ground, and just to the left of the car. Is there a gap there, or is it? There is a gap.
Sorry, I can answer. There's a private pathway, I believe.
No. So the left of the car. So you see the post and rail, and it goes round. Just there. Is that a gap? Okay. So and there's no, and there was when I went, there's no sign to say private property keep off. It does have that sign there for that little path there, as I understand, but there's no other sign to tell me if I was trespassing on that. So there's not a gate, there's not a sign. So as someone who was rambling about wouldn't know, I wouldn't have to go through a gate or go over the post and rail, and there wouldn't be a sign, would there? And my other question, which you had said with the path there, is that path for the house? And then if we go back to the other one, yeah, that's fine. So that's fine. That's what I thought it was. So that's fine. So thanks. So I've got an image that's 8 years old on Google here, and it looks totally different. But so thank you for that.
Councillor Pritchett, did you?
Just a quick one. You mentioned the conservation officer. Has his comments been put on the public portal, public viewing on the portal?
Yes, they have, Councillor Pritchett.
When did they go on?
They went on earlier today.
That's not very good for public consultation and councillor scrutiny, is it?
Sorry, did you have a question there? But Councillor Cumbers, did you want to? Yeah.
We know the original application. Unfortunately, the applicant, some of the answers were obviously untrue. And one of them in particular was about the biodiversity, which would have included badgers. And of course, apparently badgers forage on the site, and badgers are a set is very close. And I'd have thought that should have been the question of the badgers and how that could possibly any problem could be mitigated should be, I would think, should be part of the outline planning permission. Not left as some sort of condition to be sorted in the future. If it's not good enough for the badgers, then I think that's leading to a possible refusal. So I can't quite understand why the report doesn't make any mention of badgers.
Yeah, thank you, Chair. The because this site is within the built-up part of an existing housing estate, there's not actually a planning or legal requirement to actually assess the impact of the proposal on any form of ecology, not just badgers. It's simply not a validation requirement for an application on an existing residential development such as this. That said, Chair, we are aware, obviously, of foraging badgers in the certainly the adjacent wooded area, around the scheduled monument and the overgrown area in that respect. So, again, should members be minded to approve the outline application, what you could do is impose a condition requiring the submission of a badger check-in survey to be submitted with the future reserve matters application.
Sorry, you've got a supplementary.
It's another question, I'm afraid. Just now you mentioned application number 020388, which is very close to that that area, and that one ending with 388. They did get reports, I think, from the county council about badgers and so if it was appropriate for that application, why is it not appropriate for this application?
Sorry, can we have the application reference again?
Yeah, Chair, if I could just come back on that. The reason why it was a requirement in that case was the application that actually related to the development of this housing estate. So at the time, this was a completely undeveloped site. What you have now is effectively a piece of leftover land within the context, the setting of an existing residential estate, and it's just not a validation requirement to assess ecological impacts when you have a site on a housing estate such as this.
Okay, Councillor Gordon.
Yes, I want to sort of say about the 30 metres around the motte. I know that Aldi has encroached on that, and it has been allowed on that side. But on this side, I think it's very disappointing that you think it's okay to encroach on the rest of that 30 metres this side. Because I think there should be room for that motte and for people to go and see it. And also as well, on that green, the residents actually mow it, and they've been mowing it for years, and they've been having get-togethers and stuff.
Sorry, can we
And
have
it's
the
an
question?
awful shame. Now, I just think that just because Audi's done it, the other side, it shouldn't really be done this side.
Sorry, sorry, can I just paraphrase the question?
Yeah.
Is the 30-metre boundary around the motte a valid item to be considered?
To the best of my knowledge, Chair, there isn't what you would call a 30-metre exclusion zone around the motte. As I say, the advice and the guidance that we've received from our conservation officer is that what you have to do is consider the impact of the proposed development on the setting of the scheduled monument. There isn't a black and white distance from whereby if you're on one side of the line, development would be acceptable, and if you're on the other side of the line, it wouldn't. It's a more subjective judgment that members need to come to in terms of the impact on the setting of the monument. And as we said before, the position of the conservation officer, which is consistent with Historic England previously, is that the harm to the setting of the monument has already occurred by the much larger developments that have been allowed to take place around it. So their stance on this is that the addition of a further dwelling into that location that's being proposed would have a neutral impact on the setting of the monument, because the harm has already been caused and this wouldn't make it any worse.
No, but I think the question was, is there a 30-metre boundary line protecting the motte? I know there's an older map that Councillor Gordon has produced, but that is not on the current maps. Sorry, Councillor Gordon.
I have got them already done. If I could just give them out just to show people. I know they've been amended apparently, but I've got them if people want to see them.
I mean, as per the discussion you had with Louise prior to the meeting, the map has no policy that goes with it to actually validate that map as a policy, and therefore a 30-metre line.
Sorry, if I could. It would give you the indication of where the line would have been if you could, because part of the line, where the land slopes down, it's across there. Where the land slopes down to the bushes, that's where the line is.
I think that we're very into the debate, and we're not. So I'd like to move on at this moment in time, unless there's any other different questions. Councillor Cumbers.
And could I just say that I did ask for this to be deferred because I wasn't happy about the report. I thought there was too much information missing and some information I believe was incorrect. Anyway, I have another question now. People can see that bit of fence in there, those few bits of wood. The report actually says, let me get this right,
Sorry, the question is.
Yeah, sorry. The officer is trying to indicate that people can't get onto that site, and he actually said, by virtue of the timber post and rail barrier that surrounds the site, it is not actually accessible. Do you think that's not accessible? I mean,
This is not a question, Councillor Cumbers.
Why did you write it?
Sorry, yeah. Tom.
Sorry, I appreciate that all planning applications can get quite emotive, but I think we just need to sort of remain calm and not be sort of accusatory in that. So I think there is a question in there, and I think the question is the officers saying that the post and rail fence is there to say that the space is not public space?
Yeah, Chair, that is not a formal access for pedestrians onto that piece of land. I mean, we heard earlier, I think it was Councillor Higgins who said he had a Google Earth image on his phone, which is probably the same image that I'm looking at on my laptop right at this moment in time. And effectively, what appears on that image in front of you on the screen as a potential gap in the fence is nothing more than a very small corner section that's actually been taken out. It's by no means a formal access into that area for members of the public, and nor was it ever intended to be.
Again, I'm sorry that that this is all entering in. I did ask for all these things to be done outside of this meeting, but that's what we're being told, and there is no other entrance. That is the entrance.
But I think as
no, so no.
Sorry, we need to go into a question here, or we'll take this into debate.
Why has the officer said it?
Because there is no entrance into it, as we said. There may be broken, maybe whatever, but there's no there's no entrance into it.
You mentioned.
Sorry, I don't want to get into debate at this moment in time.
Yeah. Apologise to everybody because I had wanted all these questions answered before this meeting.
Sorry, if we're ready to move on, Councillor Cumbers, remember your microphone, please.
Sorry.
And Mark. Yeah. In that case, we will move on to the speakers for this application. And the first speaker for this evening is Ian Garnell, who's the agent for this site. If you'd like to please come forward. You probably heard the instructions earlier. You'll see a small face on the microphone. When it goes red, you're live. You'll have 3 minutes from when you start speaking. Tom will give you a 30-second warning, and if you can bring it to an end before that 3 minutes, else I'll pull you to a stop. Thank you very much. Please continue.
Thank you. I'd like to start by thanking the planning team by working in a collaborative and productive manner on the application, and I appreciate their recommendation for approval. I won't go through the planning policy on why the application should be granted, as Mark has already gone through this in depth, but instead I'll go through some of the objections raised from the neighbours, give some justification which hopefully should alleviate some of their concerns. Number one is the overdevelopment. As this is currently an outline application, as we've discussed, Mark's discussed it, when we do the reserved matters application, we will ensure the design is a well thought out, considerate scheme, and certainly will conform and follow what we've done on the indicative site layout. That is confirmed. Number 2, impact on amenity and loss of public open space. The site in question is not adopted public open space, and in addition to this, everyone had the same opportunity to purchase the land at auction. Number 3, loss of visitor parking spaces. There will be no loss of visitor parking spaces. Access is off a lawfully adopted highway with the plot having ample off-street parking. 4, impact on wildlife habitat. Once again, this is an outline application. Full landscaping details will be provided within the reserved matters application. We will ensure the site will have a net biodiversity gain, providing more habitat for wildlife to thrive in the future. My client is more than happy to add lots of different types of habitat, hedges, bushes, and we will work with the planning officer to ensure this is a net gain. Number 5, disruption to neighbours during the construction. Whilst it's not a valid planning policy objection, during the construction phase, the project, our client will be happy to liaise with adjacent neighbours to cause at least inconvenience as possible during the construction phase. We are happy for the condition on the approval limiting the hours of construction to normal working hours. I'd like to thank you for giving me the opportunity to articulate a valid response to the raised concerns.
Thank you very much, and thank you for being brief. Can I ask any members if they have any questions? Councillor Higgins.
Thanks for the presentation. You mentioned about the public open space. I've just Googled and then at the auction, because you said about the residents could buy it. The auction says it's a level site of public open space of approximately 621 yards. So I don't understand where we're going with it, because the auction clearly is saying, and it was the guide price is 2,500 plus, which I just think if anyone was thinking of buying it for development, you wouldn't guide price that at 2,500. But
Guide price
it's clear. It says this is public open space.
Well, firstly, guide prices are always set low. You know.
Well, I know that. But not if you was going to buy that in an auction for building, it would be 2,500.
Well, my client obviously did his due diligence. It might have been a typo on the auction papers, but obviously my client knew that it was within the mountain plan and it wasn't adopted public space, as Mark has covered.
Okay, it's just as I say, it does say here. So what Councillor Cumbers was asking, and probably will come up a bit later, it's clear it's public open space. And I don't see, when I've looked into the papers, none of this, I don't think the councillors.
Sorry, what question are we?
Well, I'm going to say is, because it'll probably come up a bit later, because I don't think either the council has explored this public open space or then the applicant, because it was maintained by Gelson's before. So Gelson's maintained this before, didn't they? And they cut it for however many years. And the picture on the auction, there's even less post and rail fences on this one, if we're going to have this argument about post and rails and access, because obviously it's clear. So
can we put this back in? Yeah, Councillor Cumbers, what questions do you have for the applicant?
Did ask.
Yeah, sorry.
Yeah, I don't know whether it's quite the same as Councillor Higgins' question, but I've got a video at home of that auction, and the auctioneer, he repeated the fact that the site was between 9 and 15 Navigation Way close, and it was public open space. So you bought it as public open space. Can you just confirm that? Thank you.
Tom to come forward with that.
I think it's difficult. We can't comment on what an auctioneer may or may not have said. They may have been using the term just in lay terms, but I think the point is this is not a designated public open space, so it doesn't attract any protections other than being a piece of land that is open and in the public.
Yeah, the question was, as I understand, Gelson's, from what on the auction, Gelson's were cutting it, maintaining it. So that must have come from the council when it first had it. And these kind of are open spaces, public open spaces. And so were you aware that Gelson?
It is exactly that. Gelson were looking after it. If it was adopted, then the council would have been cutting it.
And that's not always the case.
No, it's not always the case.
No.
But
so that's
by Gelson's looking after it, it does not imply that it is adopted public open space.
Well, Well, I'm not. I'll come to debate on that one.
Councillor Gordon.
Thank you. Yeah, you mentioned that the visitors' car spaces at the bottom, where you're proposing for the building. You're saying that we won't lose that, or they won't lose that, I should say. But those 2 car parking spaces will become part of the driveway, won't they, for the
They are
house?
actually visitors parking spaces. That is a hammerhead turning of a close. So if someone's parking illegally on a hammerhead or in a turning area, that's not a valid. It's not being designated on that scheme from Jelson's that it was.
Right. Oh, I've always understood that as visitors car parking.
Mark, can you elaborate on that? Sorry.
Just a point of order. There's a lot of interaction between the officer and the
sorry.
applicant here,
I didn't know.
I don't think that's quite appropriate.
Oh, apologies. Yeah. I was just saying, obviously, it's a turning head. So, but if anyone has any further clarification, if they are designated visitor spaces.
Well, no, I mean, Tom just informed me that the houses do have designated spaces on the other side of the houses. Yeah. So they are not parking spaces. Yeah, sorry, sir.
Thank you, Chair. So the highway is adopted by the local highway authority. Where there isn't an access, you can park as long as it's not double yellow lines or single yellow lines or requiring of visitor parking permits or anything like that. At the moment, people do use that area to park, but that doesn't necessarily give them a right to park there because it is just the adopted highway, basically. So if an access goes in there, the same as you would expect somebody not to necessarily park over at your driveway or anybody else's other driveway, then that's it. There are no allocated visitor parking bays. Each property has their own allocated parking space off the highway, though.
Thank you.
Thank you, Sarah. Do we have any more questions, Councillor Allnutt?
Chair, for the second time tonight, we're blending questions with debate and legal issues. But I do have a question which I need to have clarified in my own mind. I'd like to make it to the applicant's agent, if I may.
Of course.
We've been hearing about who owns the land, essentially. So what I need to know is, as far as you're aware, does the land registry recognise a legal owner of that site?
Yes.
Thank you.
Any other questions for the agent? Thank you very much for your time, and thank you very much.
Thank you.
I therefore like to call the next speaker, which is Councillor Sarah Cox, who needs no instruction on how to use the microphone, I'm sure. As before, you'll have 3 minutes. Tom will give you a 30-second warning, and if you could keep to the 3 minutes, that'd be brilliant. Thanks very much.
Thank you very much. I won't need 3 minutes as many of the issues have already been raised. I've been asked to attend this evening as a representative of a number of residents within the Navigation Close and Uplands area. I've been a councillor for the Dorian ward for a year, and this has been the most contentious and caused the most upset on my ward since becoming a councillor, this application. The area that is shown was sold as open space and has been used by the community of both Uplands and Navigation Close for the past nearly 20 years as amenity land. Children play on it, families have used it for get-togethers, they maintain it, they planted those trees on it. I would suggest under the terms of amenity land, as we are approaching nearly 20 years, there's precedents for other areas across the country where that's been considered amenity land. This is not planned development, it's opportunism. It's not part of what we are hoping to achieve for our town. The nearest space we are now leaving the children of that area is on Vulcan Close, that play park that was shown. That is a half-a-mile walk for children. There is no cut through, so we will leave that community without access to any kind of play area or safe area for children to play. The report doesn't address the wildlife on the site, as we've heard earlier, and that has been a source of joy for many of the residents who have maintained that piece of land to encourage the wildlife on there. As our town grows, it's essential that amenity land is preserved for the health and welfare of our residents. not a lot of focus goes into preserving the countryside within the town. More of it goes on to preserving the countryside from outside of our borough, outside of the small town settlements. But these small pockets of land are essential to our residents, and in particular this one that has been used for nearly 20 years by that community is essential for their health and well-being. Thank you.
Thank you, Councillor Cox. Do any members have any questions? Councillor Brown.
Councillor Cox, obviously, to refuse an application, great, reasons there, but what policy reasons would you feel as the ward councillor in the local plan that this committee may be able to tie itself onto if it was minded to do so?
Yeah, the specifics of policy, Councillor Brown, I wouldn't know. I'm here to represent the residents. I'm sure you will be advised on policy and be knowledgeable on policy. I've not received training in relation to planning policy, and therefore I'm here because the community felt they were unable to represent themselves and become quite defeated at the whole process and felt they were not being listened to.
Just come back, that just clears up. That means that we as a committee will have to do that. It's a relevant question because many of us do come with policies, and if you did have something, I think I should have the right to ask.
Councillor Cumbers.
I have never ever seen anybody sitting in that seat and asked to name policies which might be relevant.
Okay, point taken.
Quite common in my, yeah, I can remember the hose one recently, the same thing. Parish council applicants that came that didn't give us any indication as to which neighbourhood plan or local plan policies we could use.
Okay, thank you. Any more questions for Councillor Cox? No? Thank you very much, Councillor. In that case, then we will open for debate. We were already there just earlier on. Councillor Allnutt and then Councillor Atherton.
Yeah, the thing that vexes me about this issue is that it's self-evident that it's quite a good thing if it was retained as open space. It's self-evident. It's like lots of these planning issues. Why are we here debating it? But I asked the question about ownership of the land. Now, if the council was so disposed to do something like an ACF or something to get hold of the land, to make it, retain it as a public amenity in some form, because it's a good thing, that would be one direction. But this planning committee doesn't do that. This planning committee considers applications on their merits according to policies. And the thing I'm struggling with is that I accept the notion that this is a bit of an opportunist development. That goes on all the time. Builders buy odd plots of land and develop it because it's cash in the bank and it's adding to the stock of housing. So that goes on all over the country. We know that. But if someone owns it, legally owns it, I'm not certain how this planning committee can refuse a planning application because we don't like it. We've got to find a route through this. And I did hear a low valuation put on the property when it was purchased. So I do wonder whether there's another route through this, and dare I say it, whether a deferral would perhaps provide that opportunity to find another route through it, because I'm concerned that we're trying to judge a policy about what's good or bad in the context of a planning application, which we're not really allowed to do because planning rules are fairly rigid. But if I'm corrected on that, and there is a way we can do it here, then I'll support it, because my gut feeling is really this is not the right thing to do. It's a good amenity that's been established. I think the arguments earlier about what happened previously with the play area are sort of neutral in this, because that was a long time ago, and we're not here to judge why a particular developer did not develop a playground at that point in time. I don't think we can get involved in that. What we need to do is to look forward and say, look, this is a piece of land that does a lot of good for a lot of local community. and how can we prevent it being developed, irrespective of what the application is? And I'm looking to officers and perhaps more learned colleagues who can point me in the right direction.
Louise?
Yes, thank you. It's a very valid point that you make, Councillor, and I'm hearing, similar things with regards to what the community feel about this piece of land. In terms of the position we're in, it is a piece of land that is afforded no protection with any of our local plan or national planning policy. We also have a person who owns this piece of land, and in theory, we could go up there this evening and it could all be fenced off and completely inaccessible to the community. And that is a very real factor in terms of the discussions you're having. So again, I fully appreciate the issues that you raised, the concerns that have been put forward. However, the very real possibility is that a fence goes up and that land is no longer available for the benefit of which you're proposing. So I think if we just bring members back to the point that it is land within an ownership of a person who has applied to put development on that land. So again, just to bring you back to the points of the principle of development in that location as outlined in the report.
Councillor Siggy Atherton.
Thank you, Chair. I have a real issue with that. We're saying that we do each plan application case by case, but then we quoting, well, we're already impacted on amount. It won't do any more. The more we impact on something, the more damage we do. And we either do each case by case and we don't bring previous application that had an impact into it, or we don't. We can't have it both ways. I said it already, but we seem to be mixing things to suit us rather than the right way. So if we mentioning or Aldi already impacted on amount and this won't do much more, well, don't bring Aldi into it because this is a new application. It's got nothing to do with Aldi or anything else. This will impact, and we already impacted once. Doesn't mean a second impact is okay to do. I'm sorry, but that's fair.
Yes.
Thank you. I've enjoyed listening to the detail from colleagues tonight. I'll come at it a slightly different way. We've got the design SPD laying out principles of design, which include working with nature, positive public spaces, health and well-being, and then we've got other such guidance in the local plan, because we don't have a detailed neighbourhood plan here to protect places. So we're in a position, if you wanted to build somewhere, you would have to put a little public space in or more, in the design of new developments. And because of the owners, there's less adoption, there's more being retained. We're then going to say, oh, we're going to throw all that away in 3 years' time to meet Mr. Gove's targets to build a house on it, which completely throws it away. And I feel quite strongly about this one. The policies D1 and C9, and then you've got page 149 F and G about scale and massing and density, and I don't think this should be, but it's sending a message out. There's open space being bought up in a number of places, and it's sending the message out, we can go and stick a house on it. And I think there's adequate policies here to make this is unsuitable. It's unsuitable for development.
Thank you. Councillor Gordon, you, and then Councillor Atherton.
Yeah, it's to do with the Mott because it's an important monument, and for people to view it, it's going to be very, very difficult because there's going to be buildings all around it, and I think for Melton, it's important for people that want to go and see it can do so. That's another worry. Thank you.
Councillor Ian Atherton.
Thank you, Chair. I've got a couple of questions to raise or points to note. The first is the play area. The play area was part of the original planning application 02/00388. and it's quite clearly shown on the plans, and that 30-metre zone, irrespective of what it might mean, kind of divides it in half. I see no mention anywhere of any removal from that planning approval to take the play park away, be it relocated into a neighbouring estate which has no access from this estate or otherwise. And this application certainly doesn't talk about change of use of the land. We talk about the Mott insofar as it's already been damaged and therefore we're not going to make it any worse. In many ways, that's a shameful position to take. The Mott itself has not been looked after, and that itself is shameful, irrespective of who's responsible for looking after it, be this council or other agencies. It's a terrible state for it to be in. And indeed, until this planning application crossed my desk, I didn't know we had a Norman Mott in the middle of Melton Mowbray. And that I find equally shameful. Now, just to read one sentence from the official list entry about the Mount Mott at Melton Mowbray. It says in the legal paragraph, this monument is scheduled under the Ancient Monuments and Archaeological Areas Act of 1979 as amended, as it appears to the Secretary of State to be of national importance. We've let something of national importance that's over 1,000 years old go to ruin, and we should not be making it worse, in my opinion. Whether that's fundamental to this planning application or not is, to me, it is a moot point, but it should be a consideration. Whether it gives us grounds for rejecting the application or not, to be honest, I don't know. I have it in my mind that the national planning documentation does call for the protection of scheduled ancient monuments to take precedence, and that's about as much as I've got to say.
Okay, I mean, we do have the statement from the heritage, but Councillor Brown, you were next.
Yeah, I don't know whether Councillor Pritchard's minded to recommend the refusal, but if you were on D1C9, there's also MPPF 135 of planning policies and decisions that should ensure that developments will function well and add to the overall quality of the area, not just short term, but over the lifetime of the developments. You're taking away an amenity, are visually attractive as a good result, good architecture. You're overdeveloping here. So there's and I can go on down the list. They're not all relevant, but probably half of them are relevant in that section, because I think you're all talking the same thing. We're all talking the same thing. So it's about getting down to the root of what the policies are that would be suitable to make that sort of a decision. But I'll leave that over because you, Councillor Pritchard, came up with the original two.
Councillor Higgins.
I'm sorry.
Yeah, so I think as members have sort of talked about it, and Councillor Pritchard, I think raised some really good points earlier in the debate. But can we just go back to the pictures a moment? Either one to start with. The one with the so if we just go for there. So someone's talked already about, and I think the ward council said someone's parked there. So that's one image. If you look at if you go to the Google Earth one, there's two people parked there on that one. So that's 2 points in time where people park. And if you look on the road on that one, you'll see, well, you see the double yellows, and then you'll see, obviously, and I understand that the officers were saying, well, each house has its own 2 car parking spaces, and this one will have its own 2 car parking spaces. But if you visit that site, you can't really park in front of somebody else's drive. And if you go round the corner to the top where the red part is there, you'll be, even if you park on the opposite side, you'll be making it very difficult for those houses from 2 to 20 on Navigation Close to come out. And everybody gets frustrated with inconsiderate parking. And what I feel a little bit disappointed in the report. I think, as Councillor Brown said, one about the NPPF paragraph 135, but it's the Streets for Healthy Life, which then our design document talks about, our design SPD. And just one element I've dragged out of this document, which was published by the government, and I'll just quote it. Car parking is also a key function of many streets. Now, streets, just for the public and here, streets is not necessarily mean road, but streets is how the area functions. Although it is not always a requirement, a well-designed arrangement of on-street car parking provides convenient access to frontages and can add to the vitality of the street. And obviously, if you live there, and then you have a delivery, and if you look at some of the houses, how are they going to get deliveries to their back gardens if they're having sheds or whatever? How are they having visitors? Because otherwise you'll have to, because then you're on a main road. And then what happens when Ocado, Aldi, Morrison's, they're coming in to deliver? They'll end up just being in the way. And I know it's just two little spaces there, but it obviously clearly serves this area quite well. And then I think everybody else has all talked about the open space, the amenity of it. And I think Councillor Cumber spoke very well on that one. And I'll just raise one other point, which hasn't really been touched too much in the debate. Those two houses there, if you look at the Google Earth one, there's windows which point over that green space. And sadly, I don't know if they're here today. So I don't know what those windows are for their living arrangements. I don't know if it's a kitchen. I don't know, because again, the report's silent on that. I don't know if it's kitchen, living space, but in one way, they're going to look over that green space, and it sort of gives that kind of nice feel about it. Now, if we just, please, if we could go to the design of the application. Thank you, officers. Just where those two houses there. Now what we're saying where those windows are, they're going to look at car parking and brick built form. And I think, as Councillor Brown said, it's then over intensification of the site.
Remembering this is an indicative.
I know that's indicative, yeah. But I mean, wherever that's going to go, because it's so small, it's still going to they're still going to look at cars out their windows or houses or other people's windows and all the other stuff. So that's why, and I know we're just looking at the outline, it probably would have been easier if we had a full application, because then we know what we're dealing with. But I think it's going to cause more detriment to how those residents use that street. And I tried to get some information this week, but that's what I'm trying to say. And I think what some members are saying is D1 policies, EN6 National Planning Policy Framework 135. And I just would have liked a little bit more of the healthy streets would have come through on this report, just so members could have balanced that off. But I also do understand we do need housing, but these green spaces are important, and we've got plenty of green spaces to build houses on, but not so cramped in here.
Councillor Pritchett, I cut you off.
Invite any more colleagues for any specific policy.
Sorry, Councillor Gunsey.
Thank you. And I put my hand up and then put it down. I thought, I've heard, no, actually, there's something else I want to say. Right. Now, we have strived for years when we're looking at new developments to incorporate green areas. I cannot believe that we're considering building a house on a green area that we've managed to achieve on a development. I really can't understand it. And it sort of defeats the object of the years of being on planning, the years of attending planning workshops to achieve green spaces on developments to enhance the lives of people that live within that community. And I really can't believe we're faced with making a decision and having to go against a recommendation. I think that's the point I'm finding very difficult. There's no point in sort of striving to achieve those places when in the future, further down the line, they come back 5 years later, actually we want to build a house on it. And it is speculative development, which should not be able to take place on this particular site. There's plenty of other land which we can use for windfall as and when they come up. And I just wondered how much windfall we have in the bag so far, but I'm not going to bring that into the equation just yet. So I do think that it's sort of D1 is appropriate here, EN1. EN1 adverse effect on the area's sense of place. EN6 development of this site doesn't contribute positively to the individual character of the settlement. I think that's a biggie. And also the NPPF, I think it's paragraph 135, removes the existing potential of the whole development to accommodate an appropriate amount of green space. Now that to me is very important. And I would like to propose refusal on this one based on those particular policies, and over intensification of the site. And C9, removal of a green space is, albeit an incidental green space. I think that is unacceptable. Do you want any more policies there, girls?
Is it?
It's D1, compromise of amenity of neighbours. I think that's a.
If we can just go back, we've been scribbling and typing, etc. If you can just go over that.
Let's start again.
Yes,
Right.
please. That'd be really helpful.
First one is over intensification of the site. Next one is D1, and it's not sympathetic to the character of the area. In particular, A and C. A is compromise of amenity of neighbours. Or you can just leave it as not sympathetic to the area. And B is C is building on amenity. Well, it's not amenity as it's been identified, but building on green area will damage the wider context of this local area.
Building on a green area.
No. Got more to come. I've been thumbing through this and jotting them down to people. Sorry. EN1, adverse effect on the area's sense of place. EN6, development of the site doesn't contribute positively to the individual character of the settlement. And I think the last one was NPPF 135, para 135. It removes the existing potential of the whole development to accommodate an appropriate amount of green space. Any more? If you want a second, you can add some more.
Sorry, do we have a seconder? Councillor Allnutt to second.
Is that sufficient?
If we just give 1 or 2 minutes just to actually put that together. Councillor Gordon.
Could we also add something about the mart for protection of it, please? Yeah.
Appreciate.
Respect of the mart, the consultation, which I haven't seen, it was only put on today. If there is no objection from experienced consultees, it may carry a little weight in any decision, I would have thought.
Yeah, you would need to identify the harm. I mean, and there was an email earlier. Sorry, Councillor Higgins.
Yeah, could officers just bring the site map up and? Oh, I didn't know they were doing it. Yeah. And then it will just give that's the one. And forgive me, I'm just going to just speak aloud, and if Councillor Glancy and Pritchard, if this works, and Councillor Gordon as well, because as you go out, there's obviously areas where wildlife can enter that green space and come out, and obviously then the mock. But we've got the care home there being developed, Aldi there, obviously Valiant Way. If this area is closed off, then I think badgers, wildlife, all that, it closes a corridor for them to enter in and out of this area. And then if you completely close it off, what we do know when we went through the local plan examination, the biodiversity collapses, and so then no badgers, and they're protected, very much protected. And so I don't know whether that's the language that helps what those councillors were saying, but that was my view when I looked at it.
Yeah, I was just going to add, considering what Councillor Higgins has said, it could well be EN2 as well, which is about sort of creating habitat, but it's actually taking away habitat or potential for habitat. Damaging, there you go. Yeah. But we don't want to make the list too long because we know that doesn't always work.
Excuse me, are you amending the proposal now? You adding to it? Well,
Are you a second, or are you
I
happy with
will
that?
accept the amendment, providing we can come to a conclusion soon.
Yeah, so we'll just give them time to actually, so we can get the wording correct, and then we will take a break after. Yeah. Yes, I'm feeling a kind mood tonight.
Excuse me, Chair, during the interval, I'd like to make the point that that I made earlier, that there is still a need for the council to visit this particular issue, because it will come back to hit us again. If you see what I mean, we've been advised by officers that the site, notwithstanding all the evidence to the contrary in terms of custom and practice, is not protected by any particular policy that we can see in terms of generality. So sooner or later it will come back. The current owner may sell it on, and we may be sitting here with another planning application and an appeal. So I think the council, and I speak as the leader of the council as well as the planning.
I was actually going to suggest that maybe the portfolio holder for planning was to talk to the leader.
I think
of the council.
we need to take positive measures to ensure that we're not back here again. Because I don't want to see a fence going up around it, because nobody will get access to it, not even the badgers.
Yeah, which I need to remember then that it is a private piece of land. So, Louise, thank you.
Thank you, Chair. So what we have come up with, and again, please feel free to change this if you wish. In the opinion of the local planning authority, the proposal represents an over-intensification of the site that is not sympathetic to the character of the area. In particular, in respect of the impact on the amenity of the neighbouring dwellings and damage to the wider context of the estate, contrary to policy D1, clauses A and C of the Melton Local Plan. The sense of place within the navigation close development would be eroded, and the development does not contribute to the character of the settlement by developing out a green space, contrary to policies EN1 and EN6 of the Melton Local Plan and paragraph 135 of the MPPF.
There was another part at the end, wasn't there?
There was a slight addition to that while you were working. It was EN2, which is removing the contribution to the provision of coherent wildlife networks and damaging to the habitat. Well, in the local plan, in my lovely bit scribbled all over. It's the EN2 is development should contribute to the provision of coherent wildlife networks. By removing this, you're removing the potential for, as we've already mentioned, about badgers and foxes.
So damaging of habitats, is that the
And
sense?
damaging of habitats.
Okay, thank you.
Yeah.
Is that a second reason for refusal, or is that added to the previous reason?
Add it to the previous reason.
Thank you.
Is that going to be too long?
So Gordon?
Yeah, can we also add that, Mark? I know that you said that probably you won't be able to do it, I'm not sure. But if we can add to that, you know, to say that for its protection, and it gives it space as well. I think that might add to it because of the space it would have. That's NPPF 135. Yeah.
So are you happy with?
I was just going to say that, and the reference to the MOT, it's the fact that the conservation officer said there wasn't any particular damage. So to include that could then jeopardise what we've already got so far. So I hope you understand that. What we don't want to do is to reduce the sort of the impact of our decision by putting something in that has already been said. Actually, no, there's no damage.
Yeah, that's fine. Thank you.
And we look forward to your campaign for Save the Mod. Yeah.
So if I can just run this past the proposer, please. So now we've got, in the opinion of the local planning authority, the proposal represents an over-intensification of the site that is not sympathetic to the character of the area, in particular in respect of the impact on the amenity of the neighbouring dwellings and damage to the wider context of the estate, contrary to policy D1, clauses A and C of the Melton Local Plan. The sense of place within the navigation close development would be eroded, and the development does not contribute to the character of the settlement by developing out a green space, contrary to policies EN1 and EN6 of the Melton Local Plan and paragraph 135 of the NPPF. Furthermore, by removing the openness of the site, the contribution that the site makes to the provision of coherent wildlife networks would be removed, causing damage to habitats to the detriment of local wildlife and protected species, contrary to policy EN2 of the Melton Local Plan.
So, sorry, the second, are you happy with that? Councillor Cumbers, if it's relevant to this? Yes.
I just wanted to ask the the incidental green space. I mean, I would count that now as amenity space, and you know, if the solicitor agrees, can we get amenity space written into that reason for refusal?
I think the difficulty is that, yes, it may be being used as amenity space right now, but to be frank, the developer or the applicant could tomorrow or tonight go and put a fence up and block it off completely, and at that point it'd be very hard to stand up in appeal. So I think you would probably be better sticking with the wording that's currently in there as is.
In that case, we have a proposal, we have a seconder, and sorry, did you want to come in with a bit more? Sorry.
Yeah, thank you. Just the usual word of warning to members, just to take you back to the principle of the application that's been set before you this evening. It is for an outline planning application. It does not involve the indicative details which were set out as a reference point only. They were provided to show how a dwelling could be situated in that location. So just to remind members that we are looking here for the principle of development for a dwelling in this location, to focus members' minds just before you take a vote on the proposal.
Councillor on that. So then Councillor Glancy.
Yeah, so, sorry, I take the point, because that's a general point, really, isn't it? But in answer to questions, the agent on behalf of the applicant did specifically say that the indicative plan is in their mind to go forward as the plan, give or take some marginal changes. So I think the general principle is there, and we heard what we heard, and I think short of an affidavit, I think that would stand up in an appeal with great respect, because of what the applicant's agents told us when we were hearing the application.
Sorry, I'll just to clarify that point specifically. No, it wouldn't. So it is purely indicative. So you wouldn't be able to rely on that in any way. So even if you were looking to approve, you wouldn't be able to say, well, the applicant told us at the first time this is what we were going to get. It is purely indicative. So that might be their intention, but no, it is purely indicative. They could change that.
Councillor Glancy.
I hear what I've been advised, but that's as far as I'm prepared to go tonight.
Councillor Glancy.
Thank you for that little reminder, Louise. But so could you please read out the first part of our refusal? Because I think we need the words in there somewhere about by removing the green wedge or by removing the green area. That's why I have the over intensification. Sorry, because I've forgotten what you said already.
Okay, so the first part is, in the opinion of the local planning authority, the proposal represents an over-intensification of the site that is not sympathetic to the character of the area, in particular in respect of the impact on the amenity of the neighbouring dwellings and damage to the wider context of the estate, contrary to policy D1 A and C of the local plan. The sense of place within the navigation close development would be eroded, and the development does not contribute to the character of the settlement by developing out a green space, contrary to policies EN1 and EN6.
Okay. Maybe go to the vote to decline the application. Sorry. All those in favour of declining the application, please show of hands. That's unanimous. So the application is declined. At that point, we'll take a 5-minute break. So for those that wish to partake, we'll come back at 1:15 by the clock on this wall, which may be different to all the others. If we can start bringing the meeting back to order. Ladies and gentlemen, if we can start bringing this meeting back to order. Okay, ladies and gentlemen, if we can, while Mr. Pritchett is getting his final coffee, just a quick reminder, we do have somebody that's having problem hearing us. So when you're speaking on the microphone, can you please make sure the microphone is close and you're speaking within reason? And I'm looking at you, Mr. Atherton, to make sure that everybody in the audience can hear. As we agreed earlier, we'll actually bring 4.4 forward, which is application 2301159/FUL, the land off Ashby Road, Twyford. We'll bring that forward. And well, as Helen's the only one left, it must be Helen doing the presentation. Thank you, Helen.
Thank you, Chair. Yes.
So this application has been deferred to planning committee as the applicant is a member of staff. So in any other case, this application would be determined under delegated powers. The application site is located to the northwest of Twyford within the open countryside. The application seeks full planning permission for an agricultural building. We can move to the next slide, please. So this slide shows the location of the proposed agricultural building. If we move to the next slide, please. So these are the plans for the design of the building. It's considered appropriate for its agricultural use and the rural location of the site. 2/3 of the building would be used for sheep pens and 1/3 for associated agricultural storage. If I can just draw your attention to a mistake that was made in paragraph 4.1 of the report. It references that the building would be timber framed. For clarity, it'd be a mixture of timber and steel frame for the construction of the building. We move to the next slide, please. So paragraph 8.4.1 of the report onwards covers the impact of the proposal on flood risk. This plan shows that the site is not located within an area at risk of surface water flooding. So the site is circled in red on this plan. The site is not located within an area of surface water flooding or an area which would put neighbouring properties at risk from surface water flooding. If we can move to the last slide, please. So to clarify, the application is a member of staff. Planning permission was granted for a similar building in 2016, which wasn't implemented, and the time limit for the implementation has now lapsed, which is the reason for this current planning application. The site is not at high risk of fluvial or surface water flooding. The proposal would not contribute to an increased risk of surface water flooding elsewhere, and the application is recommended for approval subject to planning conditions. Thank you.
Do any members wish to ask any questions for clarification? I'll just ask one then. Maybe not the planning consideration, but there's no change in the use of livestock or the use of the field. It's just being used for the same thing, but this is just extra housing for the livestock that's on the field. Or is that not a question I can ask?
No, it's the same principle. So the proposal is the new barn and sheep pens. So it's to house existing livestock.
Okay. Thank you. So no questions? No? In that case, then I'd like to call Councillor Mick Jones, Twyford and Thorpe Satchwell Parish Council, to talk against the application. Thank you very much for your time. You've heard the previous instructions. So when you're ready, please press the face in the middle of the microphone. And when it goes red, yeah, that's the one. You have 3 minutes. Tom will give you a 30-second warning. And if you can bring it towards the end then, and then as before, we'll ask any questions after that. Thanks very much.
Okay, thank you. Right, let me start by saying that Twyford and Thorpe Satchwell Parish Council are not against development and in different circumstances would have supported this application. We find ourselves in a very difficult position. Firstly, let me give you some of the historical facts behind the Parish Council's objection. Properties in Twyford flood when the height of Gadsby Brook rises. Since 2003, this has happened several times, but has increased significantly since 2019. During a storm at the latter end of that year, there were 2 houses flooded in the village, with others under threat. The same happened in 2022, but things got worse in 2023. Storm Babette in October 2023 left 3 houses flooded and 2 more under severe threat. With the recent storm Henk in January, 4 properties were flooded, with 2 more under severe threat. The volume of water upstream entering Gadsby Brook before it gets to Twyford has increased dramatically. This puts major pressure on the brook as it passes through Twyford. It is without exaggeration to say that parts of Twyford are in real danger. It was always thought that Lewins Bridge, a Grade 2 listed road bridge forming part of the 6047, was acting as a restrictor to flow, but it has now been established that the restriction is caused by the floodplain further down. In the narrow channel as it passes through Twyford, the flow of water is fast and fierce as it reaches the floodplain. It loses its velocity, spreads wider onto the floodplain, slowing it further, and then water backs up through the village, causing flooding. Gadsby Brook has a very shallow fall between Twyford and Ashby Folville. Although this development is in flood zone 1, the land slopes and falls towards the Gadsby Brook, which is a river, not a brook, which is 212 metres from where the new barn is to be situated. The land which forms a valley either side of the Gadsby Brook is designated as floodplain. Contrary to the officer's report, the development will add more water to the already overly congested floodplain because it's proposed to funnel the surface water from the barn through land drains installed in 2000 into watercourse at the side of the field, enabling a quicker release. The floodplain cannot accommodate what is coming down from Twyford currently. The parish council believes that retention and attenuation is the way forward, and slow the release and save an already overly congested floodplain. We therefore ask you to refuse this application as it currently stands, and if the applicant wishes to resubmit, with retention and attenuation included, as long as there is sufficient volume of retention, the parish council will support it.
Thank you very much. Thank you for your time. Councillor Gordon.
Yeah.
Yeah, I just want to ask, has there been any remedial works at all, like larger culverts being made or anything?
Sorry?
Has there been any remedial works such as larger culverts or anything? Has anybody been making any real effort to stop this?
The major problem we have is the floodplain, because everybody associates a floodplain as being a flat piece of land that when the water comes down, it rushes over the top and it covers the surface. Within Twyford, we actually have a valley, and the water will only go so high up the side of the riverbank. Now, as the water flows through Twyford, it's very fierce, very fast. But as it hits the floodplain, it spreads and it loses its velocity. That's what causes it to back up through the village. Okay, and that's what's causing the flooding of the properties. Okay.
Thank you.
Councillor Ian Atherton.
Could you just clarify a point that you made that I'm not sure I heard fully or correctly? The plan for the new barn is to take the water off the barn and feed it into drainage that already exists.
Yes.
To feed into a stream that then feeds into the brook. So the drainage already exists, just the barn will, instead of the water going into the ground and into the drainage, it'll come off the roof and into the drainage. Is that the point that you're trying to make?
Is actually take down pipes from the barn, put those into drains, and then that water is to be fed into land drains that are already there. Now, land drains can consist of pot pipe, or it can also be plastic pipe that's got holes in it to drain the land. The water will flow through the pipework faster into the ditch, the watercourse, and then that will automatically spread faster into the Gadsby Brook. And that's the problem we've got.
Councillor Allnut.
Yes, I popped up to I popped up to your neck of the woods during Babette to have a look for myself during the storm Babette. I was actually looking round your patch, so I know what you're describing and the effects. My question is simply this: have you made any representations to the LLFA or the EA on this particular application? Have you contacted them and said, look, we think, and set out what you've just told us? Because
I've spoken to the LLFA, I've spoken to the Environment Agency, I've spoken to your Assistant Director. Okay, I actually attended the meeting that was held for flooding in the Melton area. I made my views perfectly clear. There was a meeting between the Assistant Director, the County Councillor, the Borough Councillor, the LLFA. My understanding is the LLFA said that they didn't understand or didn't realise that Twyford was getting it so bad. Now, what we have, and it was established at the meeting here, what we have is an anomaly. Environment Agency don't want to be involved unless it's actually the watercourse. The LLFA quote the Flood Protection Act 2010. The Flood Protection Act 2010 does not actually identify the responsibility of the LLFA to deal with this. What the Flood Act of 2010 states is it's the Environment Agency. Now, I've since had an email from LLFA that say it was codified in 2015 and it's now their responsibility. But their get out is that this development is so small, okay, it doesn't fall under our remit. So when you look at the guidance that is actually given by the LLFA, it says standing advice to local planning authority, national planning policy framework. When determining planning applications, local planning authority should ensure flood risk is not increased elsewhere and only consider development appropriate in areas at risk of flooding where informed by a site-specific flood risk assessment and will not put the users of the development at risk. Now, what we've actually got is they're giving this advice, but everybody's latching on to it's actually in flood zone 1. But nobody is actually dealing with the surface water runoff from flood zone 1. So we've got water pouring down the hillside that is actually going onto the floodplain. That increases the content of water on the floodplain. That then adds to the floodplain, which is very slow moving. It then means that more water backs up through Twyford village. And if I told you that we were a village in crisis, I'm not exaggerating. Whenever it rains very heavily, the residents are out protecting their properties.
I understand everything you're saying, and I hear, all right, I do hear this, and I've seen it. But my question was that about what reaction you've had from the EA and the LFA. Have you put any of this in writing to them? Have they replied?
They are passing the book.
No.
I can't.
Have you put any of it in writing, and have they replied?
Yes.
Ah, right, good.
I put it in writing.
Yeah,
I've written
that's
to
fine.
Melton.
That's all I want to know. You've put it in writing.
I've written to Environment Agency. I've written to
that's
Melton.
good.
I've written to the LLFA.
That's all I want to know.
Okay.
Yeah.
Okay.
That's
Thank
great.
you. Thank you. Any other Councillor Glancy?
Yes, just quickly. So are you sort of saying that because there's going to be sort of drainage pipes coming down and going directly into the watercourse, that speeds up the flow of the water rather than let it, if the building wasn't there, just beyond the land, and eventually it would soak through. So you've got that sort of time element where it's speeding up.
I'm sorry, I'm having problems hearing. Can you just speak?
Sorry. So are you sort of indicating that because of the building and it's going to have its drainage water that obviously falls, will go down the drainage pipes and then that'll then go into the water course? That is quicker, obviously,
Yes.
than if it rained on the land and it just soaked through and eventually made its way to the watercourse. So
Yes.
it's the impact of having the sort of the speedy route for the water is quite detrimental, basically.
There's percolation tests you can actually do for water drainage on land, okay? But where we've got developments, and we had a housing development within Twyford, Lewins Close, where there were 8 houses built. They insisted that and that is the opposite side of Lewins Bridge, okay? They insisted that they put water retention in there. So that water retention actually holds and then slow releases the water as it actually goes into the brook. Yeah, it's a very large holding tube, but it has a small outlet and it releases water between 3 and 5 litres per second. Okay, it basically means all that surface water does not flood down the hill into the brook. Now, I'm not sure whether officers realise significantly what the problems are, but we've got to have somebody. There is nobody in Melton Borough Council that has hydrology experience. And if you were actually to look at the catchment zone for the Gadsby Brook, it's quite far reaching. And we're building all these developments, but we're not actually taking into account what we do with the water. Okay, all this surface water is coming off houses, and it catches water and disperses water far more quickly than just grassland does.
I very much appreciate the point that you're making, and to stay away from Ziggy's wrath, we have to take what's in this application. But Ian Atherton, Councillor Ian Atherton.
So would if we were to put a condition on the application, should we see fit to include some kind of holding pond, would that go some way to satisfy your concerns?
I wouldn't say a holding pond, I would say water retention. Okay, a holding pond with livestock is not going to be very safe. Okay, but if you actually put underground retention in, and it can consist of just a concrete tube with a slow outlet, that would be more than sufficient, and we would support that, as long as it has the volume so that it doesn't become overwhelmed.
Yeah, I was actually going to ask the same, because you said right at the end of your presentation that there was a design that you would accept, and is that the design that you said you would accept?
Yeah.
Is that would a soakaway be a similar?
There is a major problem with soakaways, and that is soakaways are only efficient if the soil is deep enough and you're not going into clay. If you go into clay, you've got a major problem.
Yeah, thanks. Yeah. Do we have any more questions for the speaker? Councillor Higgins, sorry.
While I am the ward councillor and know Mr. Jones very well, he's my parish councillor in one way. Just on that, and I think just for some background, but I think what the other concern from the parish council is because the cumulative effect of these little developments, because there are other applications which haven't been determined yet, and I think you're trying to get ahead of the game by saying, okay, there's this one, and if you let that one go through, but then it starts to, it's that domino effect, and why you're coming with the strong objection is because you're trying to stop that cumulative effect as we're going through.
We're trying to play catch up as well, because we've had new properties within the village. The surface water has been directed to the Gadsby Brook, and as I say, the Gadsby Brook is not a brook, it's a river. Okay, it's designated as a river by the Environment Agency. That's increased the amount of water going actually into the brook itself. We've got this development, and we could have other developments that come along where if they eject more water onto the floodplain, we're in an even greater risk. And because we're at even greater risk, it means more properties are going to flood. And how do you tell a 78-year-old lady that there's nothing you can do because her house kitchen fills up with water? And she's had that 4 or 5 times. There's nothing she can actually do. She can sandbag it, she can do all sorts of things, but it's just devastating.
Thank you, Councillor Pritchett. A question?
Thank you. In your opinion, the increase over recent years of the brook, Gadsby Brook rising and causing problems in Twyford, is it, do you think, due to more inundations over a short period of time, housing upstream of Twyford, or is it in the north we have farmers that have improved the drainage on their arable land so it moves quickly down?
We've got a catchment area for water from Somerby Borough all the way down through to Twyford. So it's all the hilly area. Okay. Development has not helped, but neither has some of the techniques of farming. And we're getting a lot of surface water runoff, a lot of silt into the brooks. So if the LLFA and the county council would work with the landowners, we could alleviate some of the problems, but they're not prepared to do that. Okay. I would like to see this actually blocked further up the hillside.
And we need to keep
and
to
we've formed small ponds.
this application.
That's
Yeah. Thank you. Do we have any other questions from members? Thank you very much for your time. Okay, we're going to take we need to remind me of this works. Because we're getting close to 9 o'clock, we're only allowed to go to 9 o'clock unless we take a vote. So I'll pass over to Tom.
Thanks, Chair. Yeah, so in accordance with the general meeting procedure rules of the Constitution, a meeting can only last for 3 hours unless there is a motion to extend beyond that. So if there is a motion to extend and then seconded and voted upon, it can go beyond that time.
Councillor Allnutt proposes to extend. Councillor Glancy seconds. All those in favour? Yes. I was waiting for it. Yeah. So that's passed. We're okay. So now we're going to move into debate. And before we move into debate, I'd just like to pass over to Sarah for a quick comment.
Thank you, Chair. There are just a few points there raised through the questions from the Parish Council that I just wanted to provide some clarification to. And so the applicant has provided a drainage strategy. There are land drains at the site. Those land drains run perpendicular to the topography of the land, so it does actually slow the water down. That is a better solution than having no drainage at the site, which would obviously, when you have rainfall on it, potentially rush straight off that site and into the river. And the development is approximately 400 metres from Twyford and it's downstream of Twyford. Whilst I appreciate what the gentleman from the Parish Council was saying in respect of the floodplain, this is a very small minor development of a small agricultural style barn to provide some essentially shelter for sheep. This is not a major development that we are talking about by any stretch of the imagination, calculating that the floor space is around about 83 square metres, so it's very small in the context of the side of the field. The site is in flood zone 1, where there is a very low risk of any kind of on-site flooding. We've shown you the map of the surface water flooding that is generated by the Environment Agency, and that demonstrates that the topography of that site doesn't contribute to surface water flooding off the site or any surface water flooding on the site. We cannot ask for a flood risk assessment because it is in flood zone 1 and it is a minor development. So we cannot ask for that particular type of assessment. And like I said earlier, there is a drainage strategy submitted that has been available on file to see. There's no evidence that we have to suggest that this particular proposal would increase the risk of flooding elsewhere because of the size of the development, and we have no way of assessing the cumulative impact or expecting this particular development to solve any existing flooding problems upstream, essentially, in Twyford. The Environment Agency are fully aware of the issues around the Gadsby Brook. There's been significant flooding issues in Twyford, and the residents of Twyford have my greatest sympathies for that. It's devastating, and the councillor is quite correct that I did meet the county councillor, the ward councillor, and the lead local flood authority to walk around Twyford just after the Storm Babette floods. But we do need to keep it into context as to exactly what we're determining here, and it is a small agricultural field shelter for sheep that is some distance away from Twyford, a substantial distance away from any dwellings, and the risk of any flooding is incredibly minimal. Thank you.
Thank you, Sarah. Would any members, Councillor Higgins?
Yeah, just as Sarah, thank you for that. Could you just bring the map up of the flooding part, and I'll just explain, just as the local knowledge, because I live in Twyford, and so just there, so Twyford, as Sarah's pointed out, if you go down that road to the bottom right-hand corner, that's where the village is. And I believe what Councillor Jones from the Parish Council was saying is where that circle is, development there would go towards the bottom right into the brook, and that then, because that's then no matter how small, that's then why it then backs up and then backs up all the way into the village. I am going to talk more about flooding at the urgent item on there, but I think Councillor Jones pretty much said very eloquently a lot of concerns of the ward at the village, but also for many other people across the borough. And we've got while not necessarily Melton Borough Council per se, authorities have got to start looking at this. Now, talking about this application, it is small. We're going to get quite a lot of these, and I don't know whether there's certainly, I don't think, enough to refuse it because of all the reasons the officer had said. Whether there is something that with the applicant and the parish council, whether a deferment would work just in a very short period of time to see if there was something that could just help the parish council alleviate something, or by way of a condition. I don't know. I'm not necessarily the expert on that. I understand that this strategy is meant to slow it down. What I will say, just for context, is recent planning applications have come into Twyford, and the Environment Agency have said, we've seen this line because it's only just come up in May 2015, and it came to this level, whatever this blue line was. Development's gone into what normally was floodplain before, and if I've lived in that village on and off for 40 odd years, and those fields flooded, and now people are building in them and displacing water. And then all of a sudden, and it's not just because of the 18-month rainfall, in the last 5 years, the village is flooding in places it's never flooded before. It's always had flooding parts, and you see those houses with flood paths and all the other stuff, but now it's flooding even higher. And as I say, it's not just the 18 months of rainfall. Other things are changing. And at Lewins Bridge, as Councillor Jones will know, it only used to flood on one side of that bridge. Now, all of a sudden, it floods first on the side nearer Thorpe Satchville, then it floods the other side. So something's changed there as well. And that's the concern I think the Parish Council are raising. And as I say, very difficult. I'm not going to vote on this, being living in the village as such, but I just wanted for context for members to do that. But I fully support what the Parish Council has said, and I do think having that common sense approach would help alleviate the issues, because I know that some of the people who've been flooded, and there is a 78-year-old person who, and it is absolutely devastating, as Sarah has said, and so we've got to find a way through it. And even by a common sense working together, I think there is something we can do.
Sarah, did you want to just add something there?
Thank you, Chair. I just wanted to, I suppose, just say I'd be quite cautious recommending any kind of deferral for the applicant to discuss some sort of drainage strategy with the parish council, only in terms of the fact that neither are qualified to deliver any other kind of drainage strategy. They're not experts in that field. And again, we're talking about a very, very minor development here. If this parcel of land was bigger, so we're at about, I think it's just over 2 hectares of land. If we were at 5 hectares, then they'd be able to do this under permitted development without any kind of application whatsoever. So it would be a moot point entirely. So we do need to bear that in mind as well, and consider what kind of lengths we're actually asking somebody go to for something that's very, very minor here. Thank you.
Councillor Gordon.
Yeah, I know you said it's only a small development, which it is, but I think as well for those people, you know, that's been involved with all this flooding, it's the fear of flooding, and it's horrible thinking what's going to happen. And I think what Councillor Atherton suggested, which has been approved by the Speaker, I think that is an excellent idea. And I know what you're saying now, if we defer it, you know, to have a word with the applicant, but I do think this is the way to go, because it's the fear of flooding, and they will think, oh no, more flooding from this small holding. And I think we have to look at that, because it will cause a lot of mental health. Okay.
Sarah.
Thank you, Chair. Can I just remind members, we are some 400 metres away from Twyford. We are downstream of Twyford. The site is not at risk of flooding. It's in flood zone 1, and the site has no risk of surface water flooding on the site and does not contribute to the risk of surface water flooding off the site.
Okay. Councillor Siggy Atherton. Sorry, I'll come back to you, Councillor.
I think it's only come to us because it's a member of Melton Borough staff. Otherwise, it would not even be here. It would have been passed straight away. I think we need to bear that in mind.
Councillor Gordon.
Yeah, I understand what you said about the flooding and that, you know, it's you know, it shouldn't cause a lot of flooding, but we're talking cumulative. And as it goes downstream, that's the thing. And I mean, this could cause a bit more flooding because obviously there's going to be water involved from that site. And I think we have to look at that. And I think it's highly important that we do something. And if what Councillor Atherton said proves to be the best thing to do, then that's what we should do. We've got to help these people. The fear of flooding is dreadful. We've got to do something. Thank you.
Councillor Pritchett.
Thank you very much for your summary, Sarah. Does the lodge flood, and what is the next village downstream of villages, and do they suffer with a problem?
Thank you. I'm not aware that the lodge floods. I've not had that reported to me. Councillor Higgins may be able to provide more information on that. The next village downstream is Ashby Folville, where we haven't had any particular reports of flooding.
Councillor Higgins.
Could you just put that map up again, just for members? Thank you, officers. You might want, I don't know if it's easy to leave it up actually. Where Twyford is, from the bottom right hand corner to the top left hand corner, that's towards Ashby. Ashby's over there. The river flows from the bottom right hand corner to the top, and what Councillor Jones was saying is, as more water's in there, it backs up all the way into the village, and that's what happens. Sarah's correct. Ashby, there's been some work where Ashby doesn't flood now. It used to probably a few decades ago, and there used to be a flood path over a century ago. It used to flood in that village. You can see them in the village hall and things like that. I'm not aware Twyford Lodge flooding, and my grandparents used to live there as well. So I'm not aware of it flooding, and the people who live there have not contacted me about it. But as I say, all the flooding tends to be towards the village and then round Twyford. Not necessarily as it goes over, because I think, as Councillor Jones says, it spreads wide out, and then it just backs up all the way, and then you'll see the bigger purple marks in the bottom right hand corner. So for context, I hope that was helpful.
Any other comments? Councillor Glancy.
Just a question for officers while we've all been talking. You mentioned the drainage, there'll be sort of pipes going the other way. Have we got any figures to how that's going to slow the flow up?
I don't have any figures to hand, but that drainage is there already. So it's not that it is going to slow it down, it already does.
Councillor Atherton.
So I've been kind of thinking hard about this thinking hard about this while people have been talking. And as much as I suggested that we could put a condition in, I'm minded to not suggest that actually that we do put a condition in to put some kind of holding pond or other solution in place. I think my good lady wife has already said what a lot of us are thinking. If this property wasn't owned by a member of the council, we wouldn't be here talking about it. I do think, however, that we as a council outside of this committee need to look long and hard about flood prevention in the borough in much more detail. And I am aware that things are starting to move in that direction, but we may be a year or so away. I fully respect the parish council's concern about flooding back towards the village, but I think we're at the stage where for one small barn, for the odd occasion that we get such a deluge in the short term, at least, I suspect that the additional risk is negligible. I have nothing to back that up other than a gut feeling. And I think we should just recommend acceptance of this proposal as stated.
Are you actually making that proposal?
If we're at that point, I'm happy to propose.
And so anybody else has any? Councillor Siggy Atherton?
I'm happy to second.
I'll make no comment. In that case, we have a proposal to take the recommendation as per the officers, and it's been seconded. Therefore, I'd like to take that to the vote. Those in favour of accepting the proposal, please raise your hands. Those against? 1. And abstain 2. So oh, sorry. No, I thought he was against. Yeah. So therefore, the application is carried, of course, and Cumbers and Higgins also.
Yeah, and can I just say, I found this really, it's an echo.
Sorry.
I found this really difficult. Yeah, I really did. And all I could think of was 25 years ago, here in the town, the flooding was so dreadful. It was awful. We were nearly sort of washed away, the whole borough, and that led to the Brentingby Dam.
Yeah.
You know, so maybe it needs a bigger sort of.
As much as I would like to go through that, maybe move on.
But yeah, could I have that recorded as my reason? You know, it's I've just found it just too difficult.
Thank you. So that application is accepted. I want to thank everybody who's been waiting for the next one. I appreciate your patience in waiting as we move to 4.3, which is application 22/01014/FUL, the land south of Cedarwood, Lag Lane. Oh, sorry, I didn't realise people had left the room, so we'll just have to wait for them to return. I think we'll start with the next application and wait for Ziggy to Ziggy will join us. If there's anything pertinent, we'll go back across it. Sorry, Helen. So if you'd like to start the presentation.
Thank you, Chair. Just at the start, I want to let you know that following the publication of the report, 2 letters have been received from local residents in support of the application. So the application site lies within Thorpe Arnold towards the southeast of the village. It consists of an existing bungalow and adjoining paddock. The application seeks full planning permission for 1 replacement dwelling, 3 new dwellings, a new access road, public vehicle passing place, turning head, and and associated highways works. If we can move to the next slide, please. Could we move? Oh, sorry, it has moved. Sorry, it has moved. Yeah, to this one. To this one, thank you. So the limits to development for Thorpe Arnold are defined in the neighbourhood plan, and that's the left-hand plan shown. So that red line there is the limits to development that are defined within the neighbourhood plan. The right-hand plan shows the proposed dwellings would be located wholly within the limits to development. The access road would in part extend beyond this, following the line of the existing field boundary. The southern access point would serve the 3 new dwellings, so that's the new access point created, and the northern access point, which serves the existing bungalow within the application site, would serve the replacement 4-bed dwelling. The public vehicle passing place would be located to the west of White Gables, well, the new dwelling that was built recently within the former garden of White Gables. And then the turning head would be to the south of the new access, into the new access, and then just slightly to the north of it. And the local highway authority advised that this new turning head would be a highways gain. If we can move to the next slide, please. So this slide shows an illustrative view of the proposed development, and this view is taken from the east of the application site, looking at the back of the 2 properties that would be where the existing bungalow is. So they're the 2 on the right hand side of the illustrative drawing, and then on the left hand side it would be the front elevation of the 2 bungalows to the south of the site in the existing paddock. If we can move to the next slide, please. So to finish, the permission is sought for 1 replacement dwelling and 3 new dwellings, as well as the highways improvement works. The proposed dwellings would be located wholly within the limits to development, and the access road would immediately adjoin it. The development is supported by policies within the development plan as set out in the officer's report. It's been demonstrated that a safe and suitable site access and sufficient vehicle turning and parking spaces would be provided. The local highway authority supports the recommendation, and there are no objections from any other technical consultees. The application is therefore recommended for approval subject to conditions as set out in the report. Thank you.
Thank you, Helen. Do any members have any questions for clarification? Councillor Higgins.
Apologies. It's late, and so my apologies if I'm getting blindness when I'm reading the reports at the moment. But I'm sure I haven't seen it and on the pictures. So I'm just looking at 8.3 housing mix and 3 beds, and then 831, 832 sort of talks about bungalows, but if it's a dormer bungalow, I know that's just a word or whatever. It's got a staircase. It's got a staircase. Or is there any bedrooms on the ground floor of those dormer bungalows? And then when it's because it sort of talk about older people and all the other stuff, and then particularly supporting 3 bedrooms or fewer with single-story accommodation suitable for older people, and then this need and the need for smaller houses. Well, I'm a great advocate for that, but have we got the scale of the smaller houses? Because I couldn't quite grasp that when the presentation was happening. Thank you.
Yeah, so to clarify, as set out under 8.3 within the officer's report, it talks specifically about the housing mix. So that's a neighbourhood plan policy. And within that, it sets out that there would be 3 3-bedroom bungalows. All of those bungalows would include a ground floor double bedroom. So that's in 8.3.3 with adjoining bathrooms, providing flexible accommodation, particularly suited for older people. So that's how it's set out in the report.
Thank you for that. Reading lots of words is late, so thank you very much.
Sorry, any other questions then? Councillor Ian Atherton.
Could you just put up the proposed site plan again, please, and just talk about where the parking is to be? You implied or said that the parking is to be in that existing bit of road to the left of the White Gables property. Is that right?
No, that's not correct. So the parking is proposed within each site for the on-site parking serving the properties. But within the red line that's along Lag Lane, there's a proposal for the creation of a turning head, which would be for public use. So as part of the MMDR work, Lag Lane is being stopped up, so it's no longer a through road. Part of it's going to become a bridle way to the south of the site.
So the turning head would be at the bottom of the diagram where the red and blue lines join.
That's correct. So the bottom part of the red line where it joins the blue line, it's a 3-point turning head. So the southern point of the red into the proposed access for the 3 new dwellings, and then up above that. So that would be the 3 points of the turning head.
Okay, thank you.
Any other questions? Councillor Pritchett.
Are you content that the road into the site, the private road, has enough room for 2 vehicles to pass?
Can I just ask you, do you mean the access road where it's no longer the highway?
Yeah.
I don't think the access road that's no longer highway requires a passing place for the 2 vehicles. What highways have asked explicitly for is the provision of a passing place along Lag Lane.
Right.
Because once you're,
I'll be quite clear. If you're going to your home and somebody's leaving their home from the new access road, can you pass each other?
that would be something that would have to be negotiated between the residents once it's off the public highway.
I mean, I'm asking you a question now. Is it wide enough for that? The design, from what I looked at, I wasn't quite clear. That's the first question. It's also been brought to my attention that the one, and I can see the sense in this, that the passing place on Lag Lane will be used for parkers, people parking up and walking. So if you can't put, if 2 vehicles can't pass like normally on a road going in and out, surely there should be a passing place within the site.
There's no requirement for a passing place within the site, and the passing place on Lag Lane will have a sign on it to show that it is a passing place and that is its purpose, and it's not for vehicles to park so people can access
So
the
you-
bridleway.
Right. So you can't. Now, the big question I've got for you, why do the planning department think it's appropriate to have a new road outside the village envelope coming back into the village envelope? Because there are significant potential precedents for this as well.
So this is covered again in the officer's report, that within policy SS2, it allows for new development within and adjoining settlements such as Thorpe Arnold. And the neighbourhood plan is the plan that has restricted the limits to development. But the local plan is the more up-to-date plan, and therefore it takes precedent. So although in the report it's covered that the proposed residential development, so the proposed housing, are fully within the limits of development as defined within the neighbourhood plan, actually it's the local plan that takes precedent. So although the access road extends slightly beyond the limits to development, that isn't contrary to the provisions of policy SS2, which allows new residential development within and adjoining settlements. So that's why in this case it's been considered acceptable, because the local plan policy SS2 takes precedent over the neighbourhood plan policy H1.
But it's timing for somewhere like Bottisford that came after, that would take the precedence.
That's correct, Councillor Pritchett.
Councillor Higgins.
Helen's explained it, just what my question is, but 826, I think it's just a typo. It says the neighbourhood plan was adopted on the 10th of October after the neighbourhood plan was adopted on the 6th of June. So I think that should read the Melton local plan was adopted. And I was just, but Helen's then explained how the precedence is all there.
Thank you for that. Any other questions for clarification before we move on? No, in that case, I'd like to move on to the first speaker speaking against, which is Councillor Chris Gray, the Waltham and Thorpe Arnold Parish Council. Mr. Gray, if you'd like to come forward to the table. Thank you very much. Thank you for your patience and your time this evening. As you've heard before, if you press there you go. You have 3 minutes from when you start speaking. Tom will give you a 30-second warning, and then we'll ask any questions afterwards. Thanks very much.
Good evening, members. The Parish Council has welcomed the significant various amendments to this application since you last saw it, and in principle adds support to many of the aspects of the officer's report. However, the Parish Council would like to bring to members' attention the statement made in 8.10.1 relating to the foul sewerage being discharged into the existing vacuum system within Thorpe Arnold. There is already a serious problem with this system in the village in backing up and flooding properties. Now, we note that Severn Trent did not respond to their consultation letter, but they are certainly aware of the issues. The Parish Council can provide a significant level of documentation to demonstrate where we have informed them of recent failures of the system. The latest serious flooding occurred as recently as the 27th and the 28th of April, and Severn Trent further attended as recently as the 12th of May, just a few days ago, to deal with problems. Melton Borough Council has an obligation to ensure, under the Town and Country Planning Development Management Procedure Order 2010, to ensure that suitable drainage systems are put in place for development. They should ensure that the proposed minimum standards of operation are appropriate, and ensure through the use of planning conditions or planning obligations that there are clear arrangements in place for ongoing maintenance over the lifetime of the development. The sustainable drainage system should be designed to ensure that the maintenance and operation requirements are economically proportionate. We do not believe that the current system is able to cope with a further 4 dwellings, and we would thus ask the Planning Committee to refuse this application until a revised drainage scheme has been submitted, or that condition 10.5 be enhanced to include confirmation from Severn Trent that the vacuum system is capable of meeting the requirements of this development. The Parish Council would also like to comment on the Officer's Report 8.8, which states that the neighbourhood plan supports windfall development, providing that it does not adversely impact on the character of the area or the amenity of the neighbours. If you could just go back to the site plan, please.
30 seconds.
So that you can see where plot 1 is. There we are. So we would wish to see plot 1 remain a single-storey property and not a 4-bed, 2-storey property, as this would have an overbearing impact on the adjacent property of Mowbray, which you can see to the left there, with a significant loss of amenity, we feel. Now, further to all of this, we also have the problem of access to the site.
Can you please close? Can you bring it to a close?
With regard to 7.12D, which says in a scenario where the closure of Lag Lane is implemented before the access associated with this development comes forward, which is where we are now, then it would be physically impossible for the planning permission for the development to be implemented. So without permission to reopen Lag Lane, this planning permission cannot be granted. We've recently
I'm afraid I have to bring you to the end of the 3 minutes.
I'll do one more sentence, okay?
Well,
we've recently spoken to LCC Highways.
No, I'm afraid I have to put you to a hold there. Else I have to give everybody else the same amount of time. Yeah. Do any members have any questions that they would like to ask the councillor? Councillor Allnutt.
I've got 2 questions, one of which might be helpful to the speaker. But the first question is, you quoted a reference, 2010 procedures. Could you just give me that reference again? Because I'm not familiar with that and I'd like to read that.
This is Town and Country Planning Development Management Procedure.
Be much slower. I'm
right.
an old
Town and Country Planning Development Management Procedure Order 2010.
Management Procedure Order. That's interesting. Right. I wanted to ask you a question about Lag Lane.
Yeah.
Could you answer me that question? Because I think I didn't hear it as you were interrupted. Could you just answer me that question?
Right. Sorry. Yes, I was. If I can just carry on from where I was effectively.
But that question, please.
Yeah.
I need to answer the question. Yeah.
So we've recently spoken to LCC Highways, who say, so far as they're concerned, that the stop they've implemented now is as it stands, and there's no question of doing anything else until such point as an application is put in to do that. But my point is that the access to the development absolutely hinges on that bit of Lag Lane being reopened.
Thank you. Any other members have any questions for the speaker? No. Thank you very much for your time. In that case, I'd like to call forward the next speaker, Jane Brady, is a nominated villager, speaking against the application. You have 3 minutes as normal, and Tom will give you a 30 seconds warning.
Yeah,
Please, when you're ready, please start.
Right, thank you very much. I would actually also like to talk specifically about access to this development, because clearly without access there can be no development. The application proposes to access the 3 additional properties via a new road opening directly onto Lag Lane. Most of this road would be built outside the area of permitted development. The council is committed to maintaining a degree of separation between the village of Thorpe Arnold and Melton. Given the close proximity of the two, the only way to achieve this is by jealously guarding the development boundaries. In their objections, many villagers voiced the fear that condoning the building of an access road blatantly outside of the development boundary would open the door to future building. Furthermore, the proposal necessitates moving the Lag Lane bridleway stopping up point that Chris just mentioned some 70 metres south. The precise location of this turning head and stopping up point was confirmed at the public inquiry. I quote the MMDR core documents. Mr. Simons gave an exemplary demonstration, including an identification as to why that would be unsafe in highway terms, to describe why such a proposal was not acceptable. These views, which have been totally ignored by LCC Highways and the Planning Officer's reports, are supported by Leicestershire and Rutland Bridleway Association, who expressed serious concerns regarding the proposal to relocate this transition point between motorised and non-motorised traffic. The access proposal stipulates that some existing vegetation would be cut back and points to a well-established hedge which actually belongs to the owners of White Gables. Cutting this back is not an option. It also proposes widening the lane adjacent to the loft house to provide a passing place, leaving a half-metre wide verge. The dimensions quoted are at best generous and do not account for the fact that the hedge is planted on a steep slope with a drop of 1 metre or more. We fear that cutting in so close will result in slippage of the bank and damage to the hedge itself. Leicestershire clearly takes pride in its native hedges, and they are a delightful feature of the county. LCC Forestry and LCC Ecology have only considered the impact of the site itself, deeming it a residential garden and species poor field. They take no account of the threat to 70 metres of mixed native English hedgerow along Lag Lane. And finally, item 843 of the Planning Officer's report acknowledges that none of this can happen without the Secretary of State consenting to a revision of use of Lag Lane plots 88 and 89, which were obtained under CPOs. Any application for such a revision would be challenged.
Thank you, and perfect timing. I'd like to ask any members have any questions for the speaker. No, you'll get away free. Thank you very much for your time. In that case, then I'd like to call the next speaker, which is Richard Cooper from HSSP Architects, the agent and talking for the application. I'm not going to repeat these instructions. The microphone's already on. When you're ready, please start talking.
Thank you. Good evening, councillors. This application is made by 5 siblings, 2 of whom still are village residents with strong local ties. The application presents a small windfall development of 3 new homes and a replacement dwelling within the limits to development of a rural village hub. Planning officers concluded after careful assessment that it meets relevant policy. There are no technical objections from your consultees. The proposal demolishes the existing dwelling, which itself contributes little to village character, and forms new bespoke designed dwellings fit for the future, both in terms of their flexible plan layouts and their sustainability credentials. As an edge of village development, we've deliberately chosen to reflect the village's past agricultural heritage, using a palette of red brick, grey tiles and dark timber. The buildings echo the edge of village barns and recess into the surrounding landscaping. Access to the development is split. The shared access road serving the existing property is retained to serve the replacement dwelling. A new access drive serves the remaining 3 properties. The access road provides benefits which have been accepted as providing highways gain. It provides a turning place on the soon to be stopped up Lag Lane. Without this, it would appear that larger delivery vehicles, refuge collection, the library van, emergency service vehicles would have to manoeuvre within private entrance drives not part of the highway's limits. We could never understand how this was deemed to be reasonable. The stopped up road section is moved and will be visible from the new development. This reduces potential for antisocial behaviour. It does not increase it. The new drive is not visually obtrusive. It's softened by new planting, does not obstruct or interfere with important views out of the village. The relocated end of the road will be detailed with LCC's input as part of the next stage technical approval process. Should you approve this application tonight, the applicant would move quickly to ensure commencement of the development, so there is no conflict between the MMDR order and this scheme. LCC have confirmed that this sequence of events presents no legal issues. Thank you.
Thank you very much. Do any members have any questions for the speaker? Councillor Allnutt.
Thank you, Chair. You heard what was said about sewage and water flooding. Do you have any comments to make about that? Because I didn't hear any comments from you there, please.
Yeah, I'm not a drainage expert, nor does this development trigger the requirement of a fully detailed pack as part of this application stage. The officers has recommended a condition which will enable that detail to be presented and signed off by the relevant experts.
Is that the one at 10.5 in the report? Sorry, you haven't got the report in front of you. Are you referring to 10.5?
I'm referring to the condition about drainage.
Right.
I don't know the number.
Right. Okay, thank you very much.
And yeah, Councillor Glancy.
Yes, I'm interested in the height of the dormer bungalows. Are they 1.5 high, or do we know what the height is? And also I know it says in the report that the height of the two-storey dwelling within plot 1 has been reduced by 1 metre, but do we know the actual height of that dwelling itself in comparison as well to the dormer bungalows?
So the dormer bungalows are 1.5 storey houses with ground floor rooms, as the officer pointed out. I don't have the exact figures. They are fully dimensioned on your on the application portal. The two-storey dwelling is a replacement dwelling. It sits adjacent to other two-storey dwellings. Its height was reduced during the determination period to be similar to the existing two-storey houses.
Councillor Gordon.
So the 4-bedroomed house that's going to be replaced, the one that's going to replace the existing one, is that using the same road that the house is using now, the people in that house is using now? So it's just the 3 dormer bungalows that are going to use Lag Lane. Is that right?
Yes, correct.
Oh, wonderful, thank you.
Councillor Higgins.
Maybe officers could help with this question as well, because it was raised with other comments, and then in the neighbour objections, it says inaccurately identifies privately owned land, but land to be within the ownership of LCC in this MMDR part. Could you clarify what that's all about, and whether the map or whether the officers are there? Because I'm assuming, obviously, LCC being a statutory consultancy, but if it's getting planning permission and then highways were compulsory purchasing it anyway, I'm just trying to work that one out in my head, that's all.
I don't know if I'm going to be able to tell you the compulsory purchase. I'm not really involved in that. What I can tell you is that our application has been based on land registry drawings, and it's been based on the adopted highway records that we always request from Leicestershire County Council.
Thank you. I mean, to be fair, that probably answers as much from the applicants either able or willing to say, but whether the officers could also answer that. It's just, yeah, because it's obviously flagged up by the neighbours, and I think it would be just useful to learn about that maybe in the debate. Thank you.
Yes, I'm happy to answer that, Chair. So this application, as you can probably see from the highways comments that were submitted, has been in for quite a long time, and during that time the compulsory purchase orders have gone through. At the point of application, as the agent has indicated, the applicant notified the owners of the land as they understood at the point of application. That was included, and they signed certificate B to confirm that had been done. But the owners of the land have changed in terms of County Council Highways now own more of the land than they did at the start of the application process, but they were always on certificate B as being part owners of the application site. And I think one other point is, I think the scheme was amended so that it wouldn't require to impinge upon a hedge that potentially wasn't in their ownership, and that was covered in one of the highways comments, and the scheme has now been amended so that it's not impacting upon that neighbour's hedge in the same way that it potentially would have done in a previous iteration.
If I may, Chair. So this planning decision isn't affecting any potential other planning decisions of the MMDR. I mean, again, you don't have to answer it right now, but if you
Councillor Gordon.
Yeah, you said that obviously that the Lag Lane was for the 3 dormer bungalows, which is fine. But is there any way to stop any other cars from using that lane to get to other parts, to other houses? Is there any restriction of any kind that they can only go to those 3 dormer bungalows?
No, there's no gate. There would be a gate on the southern end of the turning head, which would be the new stop, the reduced stopped up barrier to Lag Lane. That's the detail that Highways would need to confirm how they were proposing to do that. But no, there's no gateway on the new drive to the 3 houses.
Yeah, please carry on.
Yeah, so really then, if somebody wants to cut through, then there'll be more traffic, wouldn't they, obviously, if people can cut through to get to places in the village, if they wish to, that is.
No, there's no connection from the 3 houses to other roads in the village. No.
Thank you. Any other questions for the speaker? Thank you very much for your time. Thank you very much. And therefore, I'd like to open the debate on this application. Would anybody like to stop avoiding my eyes? Sorry, Councillor Higgins, thank you.
Yeah, just to start it off, because I can see why, obviously, in the community, why it's raised quite a lot of objections, and I'm just confused about this MMDR. I don't know if that's a red herring or that's actually a relevant planning material consideration. And just to be blunt on that, would we make a decision which could impede something else that's happening? And I don't know. So that's the question for that. Other than that, I understand why it meets the policy SS2 and the windfall, and then with the housing that's there. It's a full application, so what we saw is likely to come through, isn't it? So and the design looked, very high standard. So yeah, I can certainly see why it's come to the planning committee. It's not necessarily going to be an easy one, but officers could work. Just that one with the MMDR. I don't want to, for example, I wouldn't want to permit something if it's causing something else, but equally, as I said earlier, you can apply to housing anywhere.
Do you answer that?
Yes, thank you, Chair. I'm just going to read what it's said in the report. So I've copied what the Local Highway Authority have advised, because I think in this case it gives a good explanation of the situation. So this is under paragraph 7.3.2d, which is the Highways comments that were made on the 12th of March 2024. So they're most up-to-date comments. So it's part of the way through that section, and it states it's the Local Highway Authority's understanding that where land has the benefit of 2 inconsistent planning permissions, both are valid unless and until the implementation of one has made the implementation of the other physically impossible. Should this application come forward first, the section of the SRO, which is the side road order, would instead be implemented to the section marked remainder of existing Lag Lane to be closed to motorised traffic, except for access. And then it goes on in the section below that to say, in a scenario where the closure of Lag Lane is implemented for its full extent before the access associated with this development comes forward, then it would be physically impossible for the planning permission of the development to be implemented. So the local highway authority sought legal advice on this, and given that the work to close up this section of Lag Lane that would prevent the implementation of this planning permission is expected to occur in winter 2025, it gives the applicant a reasonable timeframe in which to implement the access. So coming in first, which would then mean the stopping up of Lag Lane would happen at that point further south along Lag Lane. So yes, there is a conflict between what has been approved for the MMDR works and this application, but there is sufficient time for this application still to be implemented first, and for Lag Lane, the stopping up of Lag Lane and the bridleway to occur south of this point prior to its due completion, which is winter 2025. And if that was to happen, then the highways have considered that to be an acceptable option or acceptable scenario.
Thank you, Helen. And I think you've answered it, but just in real layman's terms here is so if this was permitted and that access was built, it's not going to. Are you saying it's something will happen further south? So it's not going to then all of a sudden we're going to have this that the MMDR cannot be done, or then someone has to go to government, ask for more money, and that has other impacts. So that's not what we're talking about here. So I just want to be really clear, because obviously the MMDR is significant to the local plan.
That's correct, Councillor Higgins. So as part of the MMDR work, Lag Lane, part of it to the south of Thorpe Arnold is being downgraded to a bridleway, so it wouldn't be able to be accessed by motorised vehicles. If this application is implemented before the work to complete that has occurred, which is due to be finished in winter 2024, then the point that that Lag Lane would be downgraded to a bridleway would take place south of the proposed new access. If the new access isn't implemented, then it would continue to the north of the access. It would be downgraded to a bridleway at that point, and then this planning permission couldn't be implemented.
Councillor Ian Atherton.
So I'm still a bit confused about this stop order on Lag Lane, to be honest. Where it's blocked at the moment is kind of to the north of where the new access is proposed. That access point is currently an access for the farmers to get into the fields. So if it's turned into a bridleway, I assume there'll be some kind of gate put across it. So how would the farmers get into the field should we not accept this? Or is there already an amended stop order in place that allows Lag Lane to be blocked further away from the village, thus freeing up the access to the fields? I'm unsure as to how all this kind of fits together from a timeline and approvals perspective.
The access for the field for agricultural vehicles doesn't form part of this consideration. So that was considered under the MMDR application. So all we're considering is, yes, where the proposed access is south of where the bridleway would start, and that's been approved. But if they were to implement this first, then the bridleway would happen further south of the proposed access, to the south of the turning head that would be provided as a highway gain. So I can't answer the question with regards to the agricultural access, because that doesn't form part of this application. It was considered under the MMDR and isn't relevant.
Can I add a point then that I think is relevant? Some of the comments we've made is that this application then needs to start or have started before the MMDR closes Lag Lane, and for the applicant to actually start this proposed application, they need by the recommendations you've put in, need to have the sewage plan approved before they can actually start any development of the site. Is that correct?
Except Lag Lane is already closed.
Can you, if you're going to ask your questions, please, I want to finish my question first, if you don't mind. Sorry,
That's correct,
Good.
Chair.
Yeah.
That there are pre-commencement conditions that would need to be discharged prior to actually starting work on site. And the scenario that Highways have given is that the access needs to be implemented prior to the closing up of Lag Lane.
And that can only start once they've actually commenced development of the site. Yeah.
Yes,
Sorry,
that's correct.
I'm just very plain on it. Yeah. Sorry. Okay.
Yeah, Councillor Atherton, the stopping up of Lag Lane is quite different to the temporary closure of it at the moment. So it's closed currently because there are roadworks going on down towards the Saxby Road end of Lag Lane to implement the roundabout, to build the roundabout, put all of those accesses in. So that's why it's closed temporarily. There's a difference in terms of when the side road order is actually formally implemented to downgrade that road to a bridleway. So it may well be, and I'm not that close to the MMDR works, but it may be at some point between now and winter 25 they reopen that section of Lag Lane anyway, but that would be prior to them implementing that side road order.
Right. Thank you, Sarah. That
Okay.
does make sense. Thank you.
Councillor Elnett.
Chair, I think we've got to put this into different packets. I've got to think about this application as though it's finished. And can we support the application on its merits? The rest of it about, may I put it this way, the time lag between the MMDR and the development and Lag Lane is a separate issue. That's a question of implementation, if you like. So I'm more concerned about how the application looks when it's finished, and also the impact on sewage and flooding. Now, the determination of the drainage side is going to be by the applicant implementing certain aspects before construction starts on the above ground buildings, and nobody can get in them afterwards. Now, from what I see, having read the doc papers and listened very carefully to the objectors, I think the finished product looks okay by me, except for one thing. I can't see any solar panels anywhere, but that's a different issue. That's outside this application, isn't it, really? So everything that stems from it after that is about timing and being certain that all of the conditions will be implemented. And as I've been listening, and I'm glad that Ian's now understood what's going on. That's always a good sign, because if he's understood it, then I think we're on a winner. So I think providing we can be satisfied that nothing's going to fall foul, if I can put it that way, of that timing phase, and that it can be implemented without any potential detriment to anything, then I'm sort of content with the application as it sits on its merits. The access for the farmers, that sort of sits outside this really, because that sits in its own right. There may be some inconvenience during the construction and so on, but that again is a different issue. I'm looking purely at the finished product, and I think I can support it. Thank you.
Any other members? Councillor Higgins.
I'm happy to move the recommendation. Basic, because as I say, I thought the design was quite good. And thanks, Helen, for explaining that, because that was a niggle. But as Councillor Walnut was saying, is on its merits, and bearing in mind, sadly, I think for the neighbourhood plan, it just superseded the local plan just by those few months. Otherwise, the decision probably in planning policy terms may have been different. Yeah, I'm happy to propose permit on it. But equally, I mean, as I say, I can see the concerns from the residents. If I was going to try and refuse it, I don't know a policy I could hang that on, and that's the problem decision makers will have on that. So I'm going to propose permit as per the recommendations. Thank you.
Thank you. So we have a proposal. Do we have a seconder? Councillor Siggy Atherton.
Happy to second.
Second. Okay, so in that case, we can. Sorry, Councillor Gordon, please carry on.
Because it is a bridle lane and there may be riders on horses, would there be room when the car's going by? Because obviously you have to give them space, and that's what I'm a little bit worried about. You know, I don't know.
I'm assuming really that doesn't change. It's not a bridle way at the moment, is it? It's a road. Yeah. Yeah. In that case, then, can we take the proposal to accept the recommendation forward to the vote? Those in favour of accepting the application, that's unanimous. Thank you very much. And thank you for the patience of everybody waiting this evening. We have one final application, which is application 14/00777, outline. This is the land behind 3848 High Street, Waltham on the Wolds. And I believe Louise is going to make a short presentation.
Yes, thank you. There's no visual presentation for this item. It's not a planning application, it's a deed of variation. So only the changes proposed would be to the signed Section 106 agreement. Doesn't impact on the details of the planning permission, such as the design, the layout, the access, or any of those details. As set out in the report, the existing agreed Section 106 limits the affordable housing to a maximum number of 6. The proposed amends the Section 106 to remove the word maximum. There will be an amended tenure as proposed: 4 affordable rent, 20 rent to buy, and 2 shared ownership properties. So again, not giving you a detailed presentation, but within the report you'll see the various dialogue that has taken place between officers, platform, and the parish council. There's been various attempts to reach a common ground between the wishes of the community and the parish council, and obviously the request of platform. Unfortunately, that dialogue and discussion has never come to fruition, and there's an additional layer here in terms of funding by Homes England. So you'll notice one key part of the proposal is to remove the local connection cascade. Now, members will be aware that even if officers haven't recommended a local connection cascade to some applications, we say to you it's up to you, and we try to assist you because we do appreciate that is a very important element when it comes to affordable housing. In this instance, I can't give you that option, and I can't support you to implement any kind of local connection cascade criteria. The reason for that is purely down to the funding. Any Section 106 agreement associated to this additionality, platform housing would then not be able to get the funding from Homes England. So that option is not available in this instance. So within the report, I have detailed that further for you. Officers have taken the view that affordable housing is welcomed, and that is the significant benefit to the borough as a whole, which has led to a recommendation to accept the proposed deed of variation in this instance. Thank you.
Thank you, Louise. Do we have any? Councillor Pritchett?
Thank you. I've read the report. Can I ask that you, outside of planning law, contact the Director for Housing and Communities to see if we can have some widespread advertising, firstly making available our own waiting list. And I do appreciate most people will be looking for rented on it. It's not far from Melton Mowbray to Waltham. It's not far from Long Clawson to Waltham. You know, you've got quite a big area to advertise in. And if we could do some proactive advertising, that would very proactive. That would working together. That would be very helpful.
Councillor Higgins.
No, I fully agree with that. Reason being is I know some members of the Somerby ward.
So is this a question?
Oh, well, yeah, just say I support it because members of the Somerby ward have moved to Waltham. So let's try and do all we can here.
If there's Councillor.
So just a clarification for those that weren't present at the briefing, and it's to do with the local connection restriction that still applies to the 4 affordable rent and the 2 shared ownership. It's just the now 20 rent to buy where that local connection restriction is being removed or not implemented, not required.
So there is another part within the report. It's the 2 shared ownership, I think, that it also removes it from. So it sticks with the 4 affordable rent, but then the rent to buy and the shared ownership, the local connection cascade is removed. And the reason for that is one of the properties has been marketed in accordance with the Section 106 agreement and hasn't been nobody's been eligible for that, so it's stood empty for 6 months. So the 20 rent to buy and the 2 shared ownership will have no local connection cascade, and the 4 affordable rent will stay as per the existing Section 106 agreement.
Thank you. In that case, then I'd like to call forward first Councillor Gray again, if you'd like to come forward. Thanks. I won't make the instructions other than the 3 minutes. Yes. So as no further forward, Tom will give you a 30-second warning. If you could please then wind up at that time.
Right, this is the second time the developer has applied for a variation to the Section 106 agreement. This being refused last time by the Planning Committee in April 2021. Planning permission was granted for this development in 2016 for 26 units with an associated S106, as you're well aware, that included provision for 6 affordable housing units, the 10 years proposed being 4 affordable rent and 2 shared ownership. As a parish council, we oppose point 3.7 for the wish to remove local connection and nomination requirements of the rent to buy and shared ownership units. Local connection criteria were set out on a cascade basis composing those resident in Waltham, those recently resident in Waltham or with strong connection, adjacent parishes and wider Melton rural area. The parish council feels that owing to the positioning of this site in the centre of village, we would not wish to see some of the problems experienced elsewhere in developments in Waltham, where what might term outsiders have been granted housing and have proved not to be compatible with village life or location and have caused significant problems. Furthermore, those with a Waltham connection ought to be given priority in being housed on this development. Platform Housing, as a provider solely of affordable housing, purchased this site with a clear lack of diligence into the terms of the original planning consent. This is something which Judith Wise of Platform admitted back in 2020, and the parish council doesn't see why the Section 106 should be varied on the basis of this lack of diligence to further allow Platform Housing to access Homes England funding, which it otherwise would not be entitled to were the local connection criterion still to be in place. This request for variation is simply about money, in that Platform want the Homes England funding and has no regard whatsoever for parishioners. Furthermore, this site is not a rural exception site, and the request to remove the local connection criterion goes against the total ethos of the local and neighbourhood plans and the wishes of the community. Now, it should be noted that as of this moment, the site is approximately 75% occupied, and as such, Platform are in clear breach of planning consent as it stands. We're rather dismayed that Melton Borough Council has taken no action to prevent occupancy of dwellings, and in this regard, Platform is simply riding roughshod over the planning process, in that it's paying no regard to the conditions therein. What we now have is occupied dwellings and a fait accompli, as doing nothing else is going to be extremely difficult.
30 seconds.
Several times during construction, things have not been complied with, such as the landscape management plan or drainage scheme, and NBC have failed to issue stop notices, which could easily have done until these matters were resolved. Planning is supposed to protect the well-being of current residents, and we don't feel in this case that Melton Borough Council has actually complied with those aims. So we're asking you please to not add fuel to this fire by agreeing to the variation of the 106 agreement, or you will have some very unhappy parishioners.
Thank you very much. Do any members have any questions? Councillor Siggy Atherton?
Thank you for that. Where did you get your 75% occupancy from? Because I went and had a look and I walked around and there were only 4 houses occupied. The other ones were all standing empty.
That's not right. No, it's definitely occupied to that extent. How recently have you been?
Only 3 days ago.
Okay. No.
Any other members have any questions for the speaker? No, thank you very much for your time. Thank you. I'd like to call forward the next speaker, Val White, an objector speaking against the application. Thank you very much for your time and for your patience. When you're ready, press the face in the middle and you have 3 minutes.
Okay. Hello. I would like to object to this deed of variation. This site has always been very contentious in the village. When the original planning was applied for, there were 90 objections and not one in support. When it was passed by one vote, it had 19 conditions and an S106 attached. Part of that S106 agreement stated that only a maximum of 6 affordable houses could be built on the site. This was very unusual because normally a minimum number is stipulated. This unusual stipulation is very pertinent as to how the character of this site was envisaged and agreed. When Platform Housing first purchased the land with the planning already in place, by their own admission, they did not take note of the stipulation for a maximum of only 6 affordable homes. A bewildering oversight and lack of due diligence from a company that only builds affordable homes. When construction began on the site, no affordable house specification had been submitted or approved. This in complete breach of the S106. It's worth noting that in the wording of the S106, it states, for the avoidance of doubt, it is declared that nothing required to be included in the affordable housing specification shall be construed as requiring anything that may be inconsistent with the planning permission. Well, as it turned out, the applicant's ambition was totally inconsistent with the planning permission. Maybe if the necessary procedures had been carried out correctly in the first place, we would not find ourselves here today. This deed of variation is all about money. Platform Housing want to benefit from substantial grants for their own advantage. This to the detriment of the local community and the established principles of local planning laws. This site is not a rule exception site. The request to remove the nomination rights and the local connection criteria goes against the total ethos of the local and neighbourhood plans and the wishes of the community. The S106 agreement is a legally binding document made to signify requirements set down by the committee and to represent the policies both in the neighbourhood and local plan. To allow a developer to then change it just to suit their own requirements for financial gain makes a mockery of the whole system. I urge you to reject this request for deed of variation. Thank you.
Thank you very much for your time. If you'd like to stay there. Do any members have any questions for the speaker? No, you're away clean. Thank you very much for your time. In that case, then, I'd like to open the debate. Councillor Siggy Atherton.
I think this is the first time where we actually have somebody going against local affordable housing. Normally, we fight in tooth and nail to have affordable housing, and I'm actually baffled. I can't believe that we're going.
Councillor Higgins and then Councillor Pritchett.
Yeah, I mean, as Councillor Atherton says, I'm very supportive of affordable housing, and I do like the mix the mix of affordable housing, which includes rent to buy. It says here at 518, and I might have this wrong, it may have changed, where I thought rent to buy is as you're renting over a period of time, your deposit is built up through that rent, as I understand. That's how some rent to buy providers have told me. I don't know about this particular one. It's a shame that the applicant's not here, and I think that speaks probably volumes, because I remember the 2021, and they yeah, it was quite embarrassing, I think, as I think it was said here. With rent to buy, though, and what the parish councillor was saying, which I'll try and take the emotiveness out of it, but rent to buy is people will buy that. If they rent it, then they purchase it. They become part of that community. So it you would think they'd be invested in it because they're making a commitment to stay there. And it doesn't surprise me, as I've said before, not everyone wants shared ownership. So if there's only 61 households with shared ownership, we've got to find different ways of affordable housing, which is starter homes, which rent to buy can be as well. Just on all that, unless officers can explain why this has come back, because I do remember, I'm trying to go back to April 2021, where they were trying to platform were trying to get out of it. I can't remember what they were trying, what was refused, and then why they've come back here. And if we then say no, you absolutely still have to have the section 106 for local connection, because I really do place a value on that. Then potentially what does happen? Because if these houses are built, what then happens? Thank you.
Louise?
Yes, so within the report, there is the history of what was requested previously, and then some of the changes. And I think the last change to this, I'm desperately trying to search my papers. There was the introduction of additional market housing. So it was the maximum of 6 and then 5 market housing, but then some affordable but with different tenure. And there was various different discussions taking place as to what the parish council particularly, which represents obviously the community, what they felt was an appropriate mix and what they thought was acceptable. But all of them, that there was no middle ground that was ever made, unfortunately. And then the point of the Homes England funding basically came in and changed the entire landscape for both what we thought as officers and what platform intended as well. So that really does set out what you can and can't do. In terms of if this variation is refused, then in essence it's a discussion with regards to legal challenge and the enforceability of the 106, and then I would imagine, and Tom's probably going to correct me here, but there's a court decision, isn't there, for challenge to the 106? Am I correct? So yeah, the challenge would be through the court process rather than the planning appeal process for any breach of a section 106.
Go on then.
Is that we challenge them or they challenge us? Sorry,
Yeah, so to confirm, the way that a 106 is enforced generally would be through a court injunction. So if there was a breach of a section 106, we would look to secure an injunction in most circumstances to enforce the terms of that. Obviously, we would have to review it specifically to check whether we could actually do that, but that would be a process that we would go through.
Councillor Pritchett?
Thank you. So instead of 6 affordable houses, we're going to get 20 odd affordable houses. I think just to set the scene for, we've had the speakers, when some people are placed in rented accommodation and moved out to some villages, you feel the pain when there's a small number of disruptive youths, and I know that myself. Now here, this offer of development is completely different to the other the style of rented, because the shared ownership, as Councillor Higgins has said, to be invested into it and rent to buy. And it does give quite, and even though it doesn't have the local cascade, if you know about it, it does give you options to hopefully get in on that one.
Councillor Gordon.
Yeah, one of the advantages of this, and it's not necessarily for this application now, but if this goes through, then Platform will be able to help other people in different areas with affordable housing, and I think that's a plus, even though it's not for the area now. Okay.
Councillor Ian Atherton.
So as a planning committee, we're always dismayed when other applicants put forward a request to remove Section 106 obligations through financial viability assessments, which always seem to show that a site may no longer be viable if we stick to the rules that we've got that mandate a minimum number of affordable houses. In this particular case, I understand that it may be a financial benefit to the applicant to change the Section 106 agreement to introduce 20 more affordable houses, and I think that's a good thing. It's either change the Section 106 agreement or leave houses that are already built standing empty. If they were able to sell them without this change, they would have already. Whether or not there is a local a requirement to maintain that localization or not, if we can do something in the way that Councillor Pritchett has suggested and concentrate advertising in the borough first, that would help. But I see no reason to not accept this proposal as stated.
Councillor Brown.
Thank you, Chair. I just apologise. I've got blocked ears at the moment, so I'm hearing an echo as I speak. So if I'm not clear, just glare at me. And I just wanted to comment briefly. I mean, I think we get caught up, and it's an unfortunate cachet that's given to the term affordable housing. And I think, and I know we're talking to fellow members, we are alive to the fact that the landscape of housing is changing. And when we talk about affordable, when we talk about rent to buy, I know 3 people, personally, who are resigned to the fact that the only way they'll get into the housing market will be through either shared ownership or rent to buy. And the 3 people are my son, the engineer, my son, the teacher, and my son, the entertainment venue manager. This is the generation of young people in particular who are having to look at this as their option for the future. And I think any decisions we can take that extend access to property on a rent to buy or shared ownership basis is something we should support. And I will therefore be voting for the recommendations in the report. Thank you.
Thank you. I think debate seems to have come to a natural end. Councillor Glancy.
Nearly. Yes, with other developments, we're really struggling to achieve affordable homes. And here we have a developer who wants to give us, well, rent to buy, shared ownership, and a couple of rentals. I fully support this. It's a shame we can't use the local sort of cascade, but as we've already said, if we can advertise it and push this, we may well benefit local people.
Councillor Siggy Atherton.
Since so many of the houses are already empty, and if local people wanted to in Walton, why haven't they? If that is so important to them, and they haven't. We walked around, we looked at them, the majority are empty, so I really don't understand the issue.
Can I then look for a proposer to accept this recommendation? Councillor Ian Atherton. And again, So yeah, we won't make any comments whatsoever. So we have a proposal to accept the recommendation as per the report. I'd like to take that to the vote. Those in favour of the recommendation, and that's you. Those against, those abstaining. So one abstention. So the motion is carried. The proposal is the recommendation is accepted. Thank you everybody for your time, your patience, and your input to the meeting. I very much appreciate it. Thank you very much and good night. Sorry. Yeah. Councillor Higgins.
Yeah,